I'd like to open the June 2nd meeting of the Raritan Township Zoning Board of Adjustment. The notice requirement of the Open Public Meetings Act have been satisfied by the placing of a notice of this meeting on the bulletin board of the municipal building, filing same with the township clerk, the Hunterdon County Democrat, the Ledger, and the Trenton Times. Amy, roll call, please.
Mr. Roger Aarons,
Here.
Mr. Kevin Cool,
Here.
Cynthia Schaefer. Here. Steve Farcio,
Here.
Randy Block,
Here.
Jim Ferraro,
Here.
Brad Perry,
Here.
Bill Cummins,
Here.
Russell Damji,
Here.
Board Engineer Mr. Tony Hajar,
Here.
Board Attorney Mr. John Drill,
Here.
Landscape Architect Mr. John Morgan Thomas, Traffic Consultant Mr. Jay Troutman, Board Planner Ms. Jessica Caldwell, Township Assistant Planner Mr. Jeffrey Vaccarella, Board Stenographer Ms. Jackie Clapp.
There are no comments tonight, no announcements, no distribution in correspondence. However, we do have minutes for the May 5th meeting. Has everyone had a chance to review the minutes? Are there any corrections or changes? Can I have a motion, please?
Motion to approve the minutes?
Second, Brad Perry.
Amy, roll call.
Mr. Roger Aarons,
Yes.
Mr. Kevin Cool,
Yes.
Ms. Cynthia Schaefer,
Yes.
Randy Block,
Yes.
Jim Ferraro,
Yes.
Bill Cummins,
Yes.
Russell Damji.
Yes.
I'm sorry, Brad, you weren't at the meeting. Can I get somebody else to do a second?
Second, Randy Block.
Thank you, Randy. Okay, our first application tonight is BOA case number 01-2020. The applicant is Universal Oil and Gas Incorporated, doing business as Liberty Fuel. Location is Block 80, Lot 28. That's 118 US Highway North. The application is for D variances for U-Haul rental services. Mr. Gruenberg?
Good evening, Mr. Chairman, members of the board. Stephen Gruenberg on behalf of the applicant Universal Oil and Gas, doing business as Liberty Fuel Stop and Mart. We were deemed complete and we provided proof of the service and publication of the notice of hearing, just like confirmation that the board has jurisdiction for this.
You're gonna have to speak up, Steve.
Yeah.
Yeah, and you got to go slower. I reviewed the form of the notice and it's acceptable. I'll have to ask Amy if she reviewed the certifieds.
No, I'm not in the office anymore.
Actually, I thought Jeff had
Okay, Jeff.
reviewed the certified for us.
Forgot about that, right.
I'm not hearing anything.
That's a good, no one's saying anything.
Okay, good.
That's a first from us, right?
No, it was digital.
Do you have a hard copy with you?
I do.
If you sent digital, that means you have digital for your file, because if you sent it, you have to scan it.
Correct.
On behalf of Jeff, the board has procedural jurisdiction because the notice itself is acceptable and the certifieds are all stamped.
Thank you. This is our application for a use variance to permit more than one principal use on the same lot. A use variance to permit a U-Haul rental business on the premises, which is not permitted. And we are also asking for C variance relief for a sign that's existing, but we want to add on to it. The permitted sign square footage is 100 square feet. The existing is 112.5 square feet. And we're asking to add 30 square feet for the U-Haul business to make a total square footage of 142.5 square feet. That sign is existing, and it is located in a setback of 15 feet. 20 feet is permitted, so we've noticed for a variance to allow that sign to stay there where it's been. Liberty Fuel is owned by Ramanjit Singh and Mandeep Kaur, a husband and wife. They lease the property from Ewing Oil Company. They do not own the property. And they've been having a service station with Mini Mart, and the U-Haul rental business has been on site when it became made aware that that was not a permitted use. That's why we're here this evening. There is a billboard on the property, and the billboard is not owned or leased or under the control of my client. That's Ewing Oil Company owns the property. We are not here to ask for any relief with respect to that billboard. Understand it's been there for a while, but we're not seeking any permission to do that. That's between the landowner and the township. So whatever approval this board would grant would not affect that existing billboard.
Right, except that one of the D variances, not just you're applying for a D1 use because you have a prohibited U-Haul business, it's also, this is going to be more than one principal use on the property. What I was going to advise the board about the Mini Mart is, if you look at the planning board resolution, it's like those other two planning board applications that were brought up by Wawa. In the Wawa case, I guess they just never found this one. That the planning board, to me, obviously looked at the Mini Mart as an accessory use. And the reason I say that is because there's a condition in the planning board resolution number 18-2000, condition number 9, that says accessory goods for sale at the filling station may be displayed out of doors only on the pump islands, but only if such display materials are contained within a suitable metal stand or rack. It just so happens this condition is identical to the condition that was in one of the other resolutions in that Wawa case that went all the way up to the appellate division. And even the appellate division commented that because of the condition in that case, the appellate division agreed with the board that obviously the planning board treated the Mini Mart as an accessory use. So the board, in my opinion, does not have to deal with that Mini Mart. The planning board deemed it an accessory use. That's done. You guys should not, and quite frankly, cannot undo that. But this billboard, if the billboard is lawfully created pre-existing non-conforming use, it's entitled to remain. But if it's not, then they should have to come in for a D1 variance, or it should be removed. So in my opinion, if this applicant is not applying for that, but if the board in granting this application wanted to impose a condition that says the billboard's got to come down within 90 days unless somebody applies for a use variance to allow it to remain, the board could do that. Or if you want to ignore it, you can ignore it. But in my opinion, the proper way to address it is this way, or otherwise it'll be there forever. And if it's not permitted, there's nothing anyone's going to be able to do about it. If it is permitted, then they'll come in and they'll show that either they had some approval which Jeff has been unable to find. But maybe they have some approval, or they'll apply for a D1 variance and then it can be addressed. So that's how I think you should address the billboard. You shouldn't, in my opinion, you shouldn't ignore it, but I give advice. You guys want to ignore it, you ignore it.
Okay, John, question. Ewing Oil owns the billboard, correct?
I have no idea.
They own the property.
I understand.
I don't know who technically
Put it this way.
owns the billboard, whether it's,
Have you guys, once we get them sworn, I'm going to ask you the same question, but have you guys looked at the billboard? Does it have like, CBS Outdoor? Does it have any insignia on it at all? Okay. Do you know what this billboard is advertising?
yeah, I really don't know. Because I agree with everything that you said about, and we sometimes do that, John. With the exception that I think they should be able to either, the owner of the property or whoever should be able to come either in with a use variance application or whatever, a certification of a
Yeah, I
pre-existing
agree.
non-conforming use.
I agree with you on that.
There we go.
So,
We tried a lot to deal with the owner. They were not.
correct. That's why I'm suggesting that if the board approves this application, that they impose a condition saying the billboard's got to come down within 90 days unless they come to the zoning officer with proof that it's a lawfully existing pre-existing non-conforming use, or they apply to the Board of Adjustment. That way, I bet you'll get some action. But that'll be up to the board once you get there. This is a picture of the billboard. Is this digital or is this?
No.
Not digital. So it's a local advertisement. And I'm trying to read what that little sign says under the billboard. Could be a phone number. But that's my advice on how to address the billboard issue.
I'm sorry, John, I really got to ask a question. We're imposing we are possibly posing a condition on this application.
No, yeah, on this application, because the owner signed the consent.
Why wouldn't you just not put a condition on this applicant and just contact the owner as in violation?
They've tried that. Okay,
What didn't work? He ignored you?
well, just so you understand, yes, just so you understand, there's other things going on in the township with unlawful uses
Mhm.
that they contact them. There's one property that's now, the township got so frustrated with being stonewalled. How many summonses were issued? I don't want to mention the name of, but you guys know what I'm talking about. How many summonses were issued in that, against that particular property? 40? More? 80? Okay, so there were 80 summonses issued over multiple year basis. So finally, the township has gone into the Chancery Division seeking an injunction, okay? But unless,
Okay.
if you,
All right.
you're assuming that all property owners, when they get contacted by the zoning officer, if not immediately, will be reasonable and will do what they should do. And all I'm going to tell you is that's not always the case.
Okay.
And in this particular case, where, and we'll get them sworn, and if you're interested, you could ask them on the record under oath what measures they've taken to try to address this, and it hasn't worked.
Okay.
That's why I'm suggesting that that's what be done. Now, we have a couple analogous situations on cell tower cases
Mhm.
where someone comes in even for a swap out, an upgrade.
Mhm.
But the underlying landscaping, for example, that the owner of the tower got,
Right.
not the cellular provider.
Mhm.
And the board on those things, because someone else owns it, has imposed a condition before you get your permission to do this, this condition has to be satisfied.
Okay,
They got to do something within a certain number of time or come to the board and ask that the board modify the condition. So in this case, I'm suggesting if the board gets to that point, I mean, the case hasn't even started yet, but if the board got to the point where they were going to grant the application, that's why my suggestion is impose a condition because the owner signed the application. The owner has consented to have this application made. The condition would be that they cannot lawfully operate that U-Haul unless somebody, we don't care who, not the applicant, but that this billboard is removed within 90 days. Or within that time period, they prove that it's grandfathered and lawfully entitled to be there, or they at least get the application in and prosecute it for the D1 variance.
okay.
John, since there are three members sitting here tonight who were not here during the Wawa, would you please talk about the US Fuel facility on Route 31, which was approved by the planning board?
You know what? Since Mr. Gruenberg represented one of the objectors in the Wawa case, okay, and he actually distinguished because the Wawa was arguing that the US Fuel, which is also Mr. Gruenberg's client, by the way, and that's who he was representing in that case, since they were arguing that, oh, US Fuel was recognized as having two uses, so you don't need a D1 variance. Why don't you explain to the three new members of the board the position you took in the Wawa case, which the board adopted, by the way. They agreed with you.
A very wise but humble attorney raised that issue.
So,
No, it really came down to the fact that the way that the township's ordinance is read is that there's only the principal use on a lot. And in the Wawa application, we argued that a convenience store and a service station are two separate principal uses, and that required D variance relief. under the
required a
township's
D1
ordinance.
variance to have two principal uses on the lot, and the board agreed. And then Wawa said, well, wait a minute. The planning board approved US Fuel, which had a gas station and a convenience store. And I advised the board that, in my opinion, if you read the resolution, the planning board felt, for whatever reason, that the mini mart was not a principal use. It was an accessory use to the gas station. That's what the planning board said. So I said, you can't reverse what the planning board did. In my humble opinion, I thought they were wrong. And I advised the board that there's a New Jersey Supreme Court case that says government has the duty to correct itself. And so going forward, if that's what the planning board meant, the Board of Adjustment could say, no, that was wrong. For all future cases, no, they're two principal uses. And in fact, I further said that under the municipal land use law, NJSA 40:55D D-70B as in boy, that gives the Board of Adjustment only the right to interpret ordinances. And in fact, I pointed out there was a trial court published case that said when the Board of Adjustment interprets an ordinance, it binds everyone else in the township. It binds the planning board, it binds the zoning officer. When the planning board interprets an ordinance, it's only interpreting it in its little case. It doesn't bind the other boards. So I said, if it comes down to the planning board saying, we think A, and the Board of Adjustment saying, we think B, B prevails. I further said that if you look at the condition though, the planning board did not say that two principal uses are permitted in the township. The planning board said in that particular case, gas station was the conditionally permitted use, mini mart was the accessory use. So that's why I am saying, based on what the board did and said in the Wawa case, because there's this condition number 9 in the planning board's resolution number 18-2000, which granted to Spartan Oil Company, the predecessor in title, preliminary and final site plan approval, conditional use approval for the gas station, and an unrelated variance, the mini mart had to be an accessory use because it wasn't mentioned at all, other than in the condition. That's why I'm saying, as to the mini mart, the planning board made its ruling. It's not like this is a new case. They're not adding a mini mart. If they were adding a mini mart, or if they were expanding it, I might feel differently. That's why, in my opinion, the Board of Adjustment should view the mini mart as being approved by the planning board, rightfully or wrongfully, as an accessory use. God bless them. Not the billboard.
Yes, once again, we agree. The other issue was that there was no evidence that anybody had raised the issue before the planning board or requested
Right,
interpretation
correct,
as to that, as that there was two principal permitted uses in the past. And it hadn't been until the Wawa application
Correct.
that had been done. But
Let's not talk about Wawa. Let's talk about this.
yeah,
case.
let's talk about these nice people here.
Right.
And these nice people have been operating a U-Haul, a limited U-Haul operation on the property without incident. And other than being told that they're in violation, that's why they're here tonight. We can't control the billboard. We don't own the billboard. We don't lease it.
Yeah,
We
listen,
lease this
Get
property.
past the billboard.
Well,
You agreed.
I'm going back to what you argued, okay? That if you are going to do a condition, I understand where you're coming from. We prefer not to have a condition because you can issue a notice of violation against the owner at any time.
Yeah.
But, we're willing to proceed forward with our application this evening. And I've got two witnesses, Mandeep Kaur, who's one of the principals, and Wayne Ingram.
All right, so let's get all the potential witnesses sworn. So do we have any board professionals on Zoom tonight? Okay, so let's get the applicant's representative, your engineer and planner in this case, and let's get the board engineer, the board planner, and the township assistant planner sworn. So Jackie, you want me to do it or you want to do it?
You go ahead.
Okay, so does everybody swear or affirm that the testimony you're going to give in this proceeding will be the truth, the whole truth, and nothing but the truth? Okay, so now let's start with the applicant's representative. Come up to the microphone, identify yourself, even though we know the spellings of your name because I have the application in front of me. Spell your name, identify yourself as I assume that you're one of the members of an LLC? Or,
I'm the president.
okay, you're
I'm the
President of the corporation.
of the corporation. Okay, so identify yourself.
I Mandeep Kaur, MANDEEPKAUR, President of Universal Oil and Gas, located at 118 US Highway 202, Ringgold, New Jersey, 08551.
Excellent, thank you. Mr. Ingram.
Wayne Ingram, INGRAM, I'll be the applicant's engineer and planner.
Tony Bedard, board engineering expert. Jeff Beccarella, township assistant planner.
Jessica Caldwell, board planning expert.
Okay.
Ms. Kaur, why don't you sit down here next to me?
So just general, speak close to the mic because our board stenographer is on Zoom. She's a lip reader, but if she's here, she could do that on Zoom. The camera's too far back. She can't read the lips, so you have to speak, enunciate and slowly.
Do you guys want the other microphones, the wireless?
Well, this is my microphone, okay? So you might as well get the wireless for everyone else, because I don't feel like getting yelled at tonight.
Jessica, and you.
Okay, as long as you, after you grab it, you put it back facing this way. I guess give Jeff a hand mic.
Let me know when I'm ready to go.
I think you're ready to go.
Okay. Ms. Cower, you and your husband are the principals of Universal Oil and Gas, Inc.,
Yes, sir.
and you do business as Liberty Fuel Stop and Mart.
Yes, sir.
And are you leasing the property in question from Ewing Oil Company?
Yes, sir.
How long have you been leasing that property?
8 years.
And do you have any ownership, you or your husband have any ownership interest in Ewing Oil Company?
No, sir.
And how have you been operating the business for the past 8 years? What type of business is it?
It's a gas station with a convenience store,
It's a mini mart?
a mini mart, right?
And a little while ago, you started a U-Haul business on site too, correct?
Yes, sir.
How long has that been going on?
2 years.
Okay, so give us the exact date when the U-Haul business on the property started.
It started almost when pandemic started.
Say when?
Almost when the pandemic started.
Right.
Can you give us a date?
I don't
An
remember.
approximate
exactly.
date? The pandemic started in March of 2020.
So a little over 2 years then?
Yes, March 2020.
Okay.
And since the time that you've been operating the U-Haul portion of the business, have you received any complaints?
Yeah, hold on.
Or-
I think the pandemic started in March of 2019.
No,
No?
20.
2020.
Okay. Mr. Vaccarella thinks that the U-Haul business started sometime in 2019 before the pandemic started.
Right, we were trying it, to see if we get hang of it. 2019 was the when, we were talking to the managers and everything. But, to have
Yeah,
the
but-
proper training.
I
And
understand,
have
but when did you first start doing anything? It doesn't matter to me if it's experimenting, training, whatever. When was the earliest? So,
Before the training, it
Yeah.
was sometime in, I'll say, September 2019.
okay, thank you.
Up until,
Thank
at some point, you received notice from the township that a U-Haul business wasn't permitted, correct?
Yes, sir.
And when was that approximately?
It was in 2020.
Up until the point, up until the present time, other than that, receiving the notice that it wasn't permitted, have you received any complaints from any of your neighbors about your operation of the U-Haul business?
No, actually, they are my customers. My neighbors are.
Okay, one of your customers is Heron Glen,
Heron Glen, right next door.
right? And what do they use your U-Haul business for?
So when they have small, for transportation, they're, I don't know what kind of equipment, but they rent it for 4-6 hours and transport it from one facility to another facility.
So is it fair to say that they're one of your good customers?
Good customers, yes.
Any other customers within the area that use your business?
It's I don't have anybody particular, but anybody close in Flemington and Ringo's.
Okay.
Just another procedural question. I'm going to ask Jeff, but it's my understanding that you got notice from the township that it wasn't permitted in 2019, shortly after you started. Does that refresh your recollection any? And again, I'm going to be advising the board that you can't hold against them, right, that they started without permission. But I want to establish when it started, and I want to get the correct date of when they got notice, because this goes to my point about the billboard. If they got notice in 2019, the original application was filed in January of 2021. Okay, so a number of years went by unless you are proactive about it. But do you know when they got the notice? Do you have a copy of the notice there?
Yeah, I don't. And
I don't-
a former attorney had represented them at that time. So that I know that
Let's ask
they're.
Jeff. I just want to get the facts straight.
It was late 2019. And just for the record, they were issued extensions based
Okay.
on that.
Okay. And when was the initial application for the D1
It was
variance?
January of 2021.
Okay. All right, keep on going.
Okay. What's the hours of operation of the U-Haul business?
9 AM to 9 PM.
And what type of vehicles are parked on the site, the U-Haul vehicles?
Some trucks, sometimes some trailers too.
And what's the maximum size length of a truck that's stored on site?
It's 26 feet,
And the trailers are approximately 6 feet by 12 feet?
6 by 12, that's the biggest.
And that doesn't mean that you have 7 26-foot trucks parked at one time, correct?
Yes, sir.
How are the vehicles reserved?
It's 3 ways to reserve a vehicle. You can go on uhaul.com and reserve it yourself. You can call 1-800 U-Haul. You can reserve it then there, or you can call us and reserve it.
Okay, you can, and somebody can actually walk in too
Walk
and
in
reserve,
and reserve it too.
right? How did drop off of vehicles occur?
So drop off the vehicle is also 9 to 9. So somebody checks them in, make sure the fuel level where they left have to be back at the same fuel level, and it have to be cleaned, and somebody have to physically check the vehicle or trailer, whatever they rented, to make sure it's in good condition to be rented to the next customer.
So it isn't permissible for anybody to drop off a vehicle outside of the hours of 9 AM to 9 PM, correct?
No.
And is that one of the benefits of actually having the U-Haul business at your service station, because people can fill up the U-Haul vehicle right there?
Exactly. They don't have to go find a service station, fill up the vehicle, and then go to the U-Haul location and drop it off there. So it's very convenient for them.
It's maximum of 7 vehicles can be stored on site?
Yes, sir.
Is that a maximum of 7 trucks, or 7 trailers, or what?
Maximum of 7 pieces, correct?
7 pieces.
Okay.
So it's not like you could have 7 trucks and 7 trailers, correct?
No, sir.
It's either a truck or a trailer.
Yes, sir.
There's some note that there were some outdoor materials and pallets that were outside the building when there was an inspection done by Mr. Vaccarella or Mr. Hajar. You're going to make sure, what was that material?
It was actually, it's the pellets that we get our additives for the diesel trucks,
I'm sorry, could you repeat that? I did not get that.
Additives for the diesel trucks?
Right. It's the pellets, the wooden pellets. They were sitting there.
Okay, and you're going to make sure not to do that
Yes.
now and
Exactly.
have them broken up much quicker?
Exactly. We will.
Okay. There's also noted that there's temporary signage on the site, and you understand that that has to comply with the ordinance, and you'll agree to do so.
Yes, sir.
And there was a recommendation about striping the vehicle storage area over the fuel tanks, which Mr. Ingram will get involved, will address a little bit more, but fair to say that you can't stripe that area, but we're willing to do signage, correct?
Yes, we will do signage.
And there was an issue about temporary American flags that if they're torn or tattered, they'll be replaced.
Yes, my apologies. Yes.
Go back 1 second. Mr. Ingram's going to explain why they can't.
Stripe them, yeah.
Okay.
I'll let him do it. I'm not
Yeah,
going to
let
testify.
him do it. Because the reason I ask, why I'm asking, is because if the board were inclined to grant the application, and if the testimony is there's not going to be more than 7 pieces of equipment, and they can only be parked in designated U-Haul parking spaces, they're going to ask, well, if they're not striped,
And I'm
they're
going to have,
be all over the site like they are now.
and I'm going to have Mr. Ingram testify
Okay.
that there's going to be signage designating the 7 spots
And
so
he'll
that people
explain
can
why
pull
they-
in there.
And he'll explain why they can't put the paint down.
That's why I said he's going to do it.
Okay. Fair enough.
And you're going to remove any temporary American flags outside of the bushes, correct?
We did. Yes, sir.
You did, okay. That's all I have for Ms. Cower.
Just one question. Is there a reason for the number of 7? It seems in looking at the plans, it's very condensed if there are 7. Is there a reason there's 7 and not 5 or 6?
Yeah.
Do you have the business for 7 trucks?
We are going with the maximum so that, it could be 2, but if we have permit for 7, that's not a problem. But if we have 5 and we have only permit for 4, then that's an issue. So we are just applying for the maximum.
What happens if an 8th truck comes back? In other words, do you have the ability, what ability do you have to limit it to 7 pieces of equipment?
Yeah, we always can tell our manager or U-Haul people that 7 is our maximum. So if there's an 8th truck that's scheduled to be dropped off here, we can refuse it.
Okay, my question is different.
No, but your question is, then why can't you then, instead of 7, have 5 and tell the manager that after 5?
Yeah, so okay, so you're saying you went for the maximum. I'm asking you, do you perceive or do you have, since you've been operating this for a while, the business for 7?
Is it fair to say that 7 gives you the opportunity to have not only just the trucks, but trailers at a variety of sizes, and that the 7 number allows you to have flexibility in the types of equipment that you're using?
Yes, yes.
So if you were limited to 5 or 6, it limits your ability to have potentially a variety of different types of trailers and sizes of trailers that the public might want.
Yes, sir. Thank you.
Could you tell me how many other facilities in the township are U-Haul dealers? In other words, that have permission to have U-Haul trucks on their site for rent?
I think Mr. Ingram has done that analysis and will provide you with that
Okay.
testimony.
Okay. And did Mr. Well, I'll ask Mr. Ingram that question when he speaks.
Okay.
Thank you.
I have a question. You mentioned that they were cleaned and when they were dropped off. Is there a cleaning station on site, or how's that?
No, clean means I have to make sure they don't leave their stuff. Sometimes they leave their boxes and all that in the back of the truck. So we have to make sure that, they take completely empty it. It's not about washing or cleaning or anything. It's about they don't have their, like when they're moving their boxes and their old stuff and all that.
You're not hosing down the vehicles and cleaning them and
No.
washing them on site,
So
correct?
No,
if they
sir.
come back dirty, how would you clean them?
So if they come back dirty, we have to send them back. Cannot accept it.
Send them back where?
With the customer who brought it, who got the rental. So we tell them if it's dirty, they have to get it clean, but they cannot clean it over there. I don't have space or I don't have facility to get it cleaned there.
And you're not doing that, correct?
No, we are not doing that. We just send it back. That's why it have to be between 9 to 9 so somebody can physically check it.
It's in the contract then probably that they sign?
Yes, sir. Yes, ma'am. It's in the contract that they have to
Okay, I
bring
have
it
a
back.
We're talking about a maximum of 7 trucks.
Maximum
Are we
7
talking
trucks.
about a maximum of 7 trucks? I hear a lot of numbers floating around.
Yes.
I think the application is for space to park 7 U-Haul trucks.
It's a maximum of 7 pieces of
Yeah, I
equipment. It's
wanna
not
make
just
sure that we're
trucks,
talking
but
about a max here,
correct,
not a moving target.
correct.
Quick question from me, Brad Perry. How many different size pieces of equipment are there? How many different variations could there be?
Like close to 20. They have 6 sizes of trailers and then 3 sizes in open trailers and then 5 to 6 sizes in trucks and a van and a open pickup.
So
That's
is,
what they offer.
so does your contract with U-Haul specify that you can only accept certain size of all these different trucks?
I don't have any such contract, like, I'm open for everything right
Yeah,
now.
but I believe you testified before, the maximum size truck on your property would be a 26 footer, and the maximum size trailer would be a 6 foot by 12 foot. Is that
Right.
correct?
Yes, that's the maximum they offer.
Okay, but in the plan, it says 33 feet.
Yeah, and Mr. Ingram's going to testify
Thank
to
you.
that, because we
Okay.
clarified that when we were preparing.
Thank you.
He said, why is the space?
Sounds like
That-
Mr. Ingram is going to have a.
Not to talk about.
Excuse me again. We're talking 7 things. About 7 trucks, 7 trailer, or mix. of
Yeah.
trailers and
Yeah,
trucks.
we're talking 7 items,
Okay.
whether it's a truck or a trailer. It won't be a truck and a trailer accounting as one item. It's either a truck or a trailer or a van.
And I have a question, if I could, who maintains these vehicles? As far as changing oil,
U-Haul,
washing? Huh?
U-Haul does that.
They come to your site and maintain them there?
We just type in when the, suppose somebody bring a vehicle out and it says oil change. So we just put it in our computer that it's disabled and have to be picked and have oil changed.
So they take it off-site somewhere and do the service?
Yeah, they have garages, yes.
Okay, so if the board were to grant this, I assume you'd be okay with the condition that says no cleaning and no maintenance of trucks and or trailers on your site?
Yes,
correct?
sir, 100%.
Do you want to just clarify that to washing? Because cleaning may be,
Okay.
making sure
washing,
somebody's
that's
out.
fine, okay.
Yes, sir.
Although I have a question about.
Is that mic on?
Okay, now it's
There you
on,
go, now
okay.
you're on.
I had a question about frequency of rentals. So how many times a day do you rent or just during the week? What's the frequency of people coming and going to the site?
So weekdays it's very less, but Friday, Saturday, Sunday, we are busy. But even if I tell you the maximum rentals in one given day is never more than 6, 7. Because we only have that much equipment.
So is there ever any?
I can't hear that.
So is there ever any, or has there?
You're out again. You get one. Take that one. If all else fails, I'll give you.
Hello? Okay. So have there been any conflicts between, people using the gas station mini mart and people, coming and going with the trucks? Have there ever been any issues just with people coming, going, backing up, accidents, things like that?
No,
Okay. Thank you.
thank
thank
you.
you.
It's turning off. You mentioned if there are extra boxes that they would have to get rid of them. Is there enough recycle enclosures for that, or where is that going?
I
In the-
have
in the dumpster
two-
enclosure and the recycling? There's enough
Right.
room?
Yes, it's enough in there. And if it's too much, we always tell them, they have to take it back with them. They cannot dispose it off there.
Do you sell boxes and tapes and stuff like that for your business?
No, sir.
Okay.
And you mentioned that it's 9 to 9. Has there ever been a situation where there's been a drop off past those times?
So if customers running late, we always tell them, call us if they are on their way and we have to wait 10 minutes, 5 minutes, we'll wait.
But it's not your normal practice to
It's
be open past 9?
no,
Is the gas station and the mini mart closes at 9?
no, sir.
What time do they close?
It's 24 hours.
Wait, how can that be? There's a condition in the planning board resolution. Okay, the finding number 32, I'll see if it was translated into a condition. Number 32 in this same resolution, number 18-20 says, the owner of the property stated that he had intended to operate the facility for 24 hours per day, but after some discussion of the issue, the applicant indicated a willingness to close the facility from 12 midnight to 5 a.m. This limitation will be a condition of any approval granted by the board. So let me just go back and guys keep on going. Oh, yes, here it is. Condition number 13. The hours of operation for the gasoline filling station shall be limited to 5 a.m. to midnight, 7 days a week. The facility shall be closed from midnight through 5 a.m. each day. So my advice to you is, unless and until you get this condition lifted, you'll end up getting a zoning violation now that they're hearing this. If you stay open past midnight or if you open before 5 a.m.
Okay. Do that.
I'm looking at the subsequent resolution, but I'm not seeing anything addressing it. Okay. Are there any other questions of Ms. Cowan?
I do. Was this, were these people operating or owning this facility when it got its approvals from the planning board?
No, it was a different applicant.
Okay, so are they familiar, her and whoever, are they familiar with all the provisions of the resolution of granting the, on the planning board's resolution granting? Are they familiar with all the, there's several pages there.
Yeah, are you familiar with all of the pages of the resolutions of approval that were granted previously before you owned a property?
Yes.
I don't think so.
No.
Were you aware of the condition that you couldn't be open before 5 or after midnight?
Yeah, that's a concern.
That was a condition in the resolution. It's fair to say that you weren't aware of all of the conditions of any prior approval?
Probably I'm not 100% sure.
Well, all I can tell you is, if you think you were aware of them, I think you're mistaken, because if you're open 24/7, the second resolution that Mr. Gruenberg is referring to was a first amendment to resolution 18-20, and that one amends a couple things, but condition 4 says all other terms and conditions of resolution 18-2000 will remain in full force and effect. And my advice to the board is, if they grant the U-Haul thing, there's going to be a condition that says all conditions in the prior resolution shall still apply. So if you want relief from that condition, you're going to have to figure out how to get that relief. And I don't want to talk about that right now. Right now, for purposes of the application, that condition applies.
Understand that condition, unless there's another resolution out there, which I'd have to find out. So I understand that a condition that all conditions of any prior resolution apply. Just don't know if there's another one subsequent to this that I might be able to rely upon.
Mr. Greenberg, have these people been shown a copy of the planning board resolution? Are they familiar with the terms?
Well, obviously, they're not familiar with the terms of it but it was attached to our application documents. We provided it to the board.
Right, Mr. Ferrara wants to know, did they read the application that you submitted?
Did you read the resolution in detail that was submitted?
I did not.
Okay, she did
Jackie,
not.
did you hear the answer?
I did not, yes, I did.
Okay.
I assume that she would not read the resolution, that the contract that she signed with the landowner would have transferred the conditions in the resolution to the contract. And
Right.
maybe that's where the mistake is, that
Well, right, but what Jim is asking is,
did you,
the resolution was actually attached to the application that
Yeah.
Mr. Gruenberg filed, and he was asking, before the application was filed, did the applicant review
read
it?
it? Yeah, okay.
Anything else for Ms. Cower? Then I'll have Mr. Ingram come up.
So, well, hold it. Can we see if anyone in the public has any questions for her?
Are there any Anyone from the public have any questions or up on the screen?
Okay.
Okay, seeing none.
Thank you.
Thank you.
Thank you.
Amy, where would you like Mr. Ingram to place that?
I guess.
Are there any members of the public here on the current application? Seeing none, why don't you put the thing right at the microphone? That way we can see it and the board can see it. We don't have to deal with the fact that no one in the public can see it because there's no public hearing on that application.
Mr. Ingram has presented testimony to this board, I'm sure previously as an engineer and planner. I can give his qualifications again if you would like.
Well, that's up to you. Do you want to get him just qualified in a pass-through and someone could be waiting out there in the wings, or do you want to get him qualified, dot the i's and cross the t's?
Let's dot the i's and cross the t's. one.
I am a licensed engineer and planner in the state of New Jersey. I've been practicing engineering for 18 years now and licensed as a planner for over 10. Both those licenses are current and valid. And I've appeared for pretty much every board in Hunterdon County at this point.
Offer Mr. Ingram as an expert in the field of engineering and planning.
Mr. Ingram is well known to the board. We accept him as an expert.
Thank you.
And why don't you give the board the benefit of your review? Before you do that, you have an exhibit marked, or you have an exhibit.
Well, this is sheet
presented.
404 of our submitted plan, so I don't know if we need to mark it or not.
And it isn't been colorized or anything. That's what's
Yeah,
been
this is
submitted to the
as
board.
included in the plan set.
Yeah, it's same way in the plan.
Same way in the
Yes.
plans.
Yep.
So we don't need to mark it.
Correct.
And so I'm just using this because it's most visually depicting of the surrounding area. So just to describe the site and our location, we are located on Route 202. To the south of us is the Heron Glen access driveway. Directly to the east, there are two residential homes that also access off that driveway. And to the north, we have another property in the B2 zone, which is a residential dwelling unit, which is non-conforming to the zone. I think it's important to note that property is in common ownership of this property owner. So they control that. It's a rental house. So, we really don't have an aggrieved neighbor in that direction. You can see in the light gray, that's essentially the outline of the existing pavement. And we are not proposing to make any significant changes to the site to accommodate this use. The darker gray is the existing mini mart, and the two boxed out areas are the existing overhead canopies, the front being regular fuel, and we have diesel to the northern end. This particular plan was prepared for purposes of showing the circulation of the site for the large trucks that would go into diesel, which would be the most restrictive. We have a total of 13 parking spaces, which is broken up between 6 in the front, 3 along the side of the building, and 4 in the rear. Our requirement is to have 10, so we do have an excess of parking. In the current, actually, in terms of lighting, I think that was a question. We have some rear pole-mounted lighting. We have one on the entry drive, but the predominant lighting seems to be coming from the overhead canopies. I could say, having driven past the site many times at night, it is a pretty well-lit site. In terms of landscaping, you can see we have pretty dense vegetation to the north, separating us from the residential unit, which you can kind of see on the edge of the page. We have our stormwater facilities, but again, thick vegetation to the east. And then there's some minimal vegetation along the southern boundary where we're proposing to place the storage area. And again, just south of that is that access driveway. The current site does not have a defined location for the U-Haul units. So, if you've driven past it anecdotally or, seen photographs of the site, there were some placed along the frontage of the property, no real defined places. So what we were proposing to do was to remove that, the visual degradation that may result in that, and place the vehicles on the southern end of the site, basically over top of where the fuel tanks are, and would be fueled. I think a question was raised about the sizes of the trucks. I think we had a miscommunication with the owner. We were assuming when they said 26 feet, they were referring to the storage component of the truck, which is what's depicted in our graphic. The truck head, hangs over an additional 10 or 11 feet. It's now our understanding that the 26 feet they were referring to is the overall vehicle. So
That's why it was
correct.
designed for
Yeah,
37.
we're designing here for larger vehicles, and I think that having the shorter vehicle as the maximum resolves one of the comments and questions from the board professionals, in that we had a bit of an overhang into existing vegetation. So if we remove all that additional length, there's not going to be an excessive overhang into that existing landscaping. Having said that, we do agree, and we think it would be something that we could add to the property to, beyond that landscaping, try and establish some additional landscaping just beyond that, to try and provide a further buffer visually into the site, which we think we have the space to accomplish.
So let's go back 1 minute. On sheet 3. I don't see it on sheet 3. That's where it says the overall length is 36.91 feet, correct?
Yes, we have the truck depicted there. That's long.
Look at the 7 parking spaces.
That was just the delineated area that was available, whether they pulled forward or back. From what, that was basically the distance of what could pull in, given that we had a 22-foot drive aisle that we had checked was clear, and then what could overhang the parking lot.
So recognizing now that the maximum overall length of the vehicle is going to be 26 feet.
Yep.
What revisions would you be making to sheet 3?
Well, we're going to reduce the size of the vehicles to reflect that accurately,
Right, so-
which will remove the overhang.
But I see that that's easy enough in the diagram of the vehicle. What changes are going to be made in those 7 spaces on sheet 3? What's the overall dimension going to say now? It's still not, it's not going to say 36.91, right?
No, essentially what it's going to show is we're going to show a 26-foot vehicle that won't overhang so significantly over the existing landscaping. And then realistically, any residual will get replaced into the drive aisle.
Right.
So the 22 feet that we show now is adequate because these are angled stalls, and that'll just widen out to be slightly more, slightly wider.
So what's the dimension of the angle? storage?
I can't do the trigonometry to give you an exact number on that, but we're not changing the curve lines.
Just ballpark.
Ballpark.
Yeah.
The dimension is going to go down to about 25 feet because they're on an angle, so it's not going to be a full 26.
Okay.
Yeah.
Will that reduce the overhang onto the existing parking stall?
Yes, that would
Okay.
eliminate that. And that's the one other change, major change that I wanted to suggest. It was suggested that we remove the drop-off vehicle over here to the north. We hadn't really seen that as a problem because clearly, we had demonstrated with the truck turning movements that it would not be interfering with anyone. But based upon the shorter length, and again, the understanding that these are not all going to be 26-foot vehicles, the suggestion was made that we move that stall and potentially, we could show 12 parking stalls on the site instead of the 13.
But now you wouldn't have to do that.
Well, so what my suggestion would be is then we would still suggest that we would like to have the 7 pieces of equipment,
Right.
but take away one of these 4 stalls in the back and designate one more for another piece of equipment, say a short trailer that's significantly shorter than a vehicle and would fit right into there. We still have a 2-stall excess of parking. It eliminates anybody having to drop a vehicle off and walk across the parking lot. And, frankly, they don't need the spaces. Anybody that's, been to the store, they simply don't use the parking.
What's the required number of parking spaces for the gas station and the mini mart? And how many do you
It's
have?
10. We currently have 13. With that revision, we would have 12, so it would still be compliant. There's no additional employee required to operate the U-Haul business. So again, with even, we'd be removing that overhang of that easternmost stall and would be proposing to add that 7th space in that row of 4 to round that out. And I think, one thing that's also been suggested, we're not saying that we're going to have 6 or 7 26-foot long vehicles. This is the maximum. So many of what you'll see there will be significantly smaller trucks, vans, or trailers. My understanding is that they realistically generally don't have more than one or two of that full-size vehicle on site because they want that variety. So I think that, that plays into the suitability of the area. The question was also asked, well, how do you fuel if you have these here? So we kind of looked at the feasibility of that. On average, they get 2 to 3 fills per week for fueling, and that's in one of the 2 tank locations. So only 2 to 3 times per week do they need to access those for fueling. And that's generally an off-peak time, and it's something that's generally scheduled. So what they would propose to do, and again, in the event that even all of these spaces are filled, which is unlikely, they would just relocate the vehicle temporarily into one of the other spaces to facilitate fueling in that one location as necessary.
And that fueling takes about 20 to 30 minutes.
20 to 30 minutes, and then it would be put, right back in its location. But again, as a maximum, and that's why we want to have 7, it provides them the flexibility to have multiple units, multiple sizes, to move vehicles around because they don't anticipate always having those 7 on site. As you've heard, people may have one that they come here to drop off. So generally, they're going to keep one open so they can have somebody drop that off and be able to accept the vehicle. Somebody had asked the question, how, what other facilities exist in the area? You can go on U-Haul's website. There's a few ways that these facilities or any U-Haul facility exists. They have their own standalone facilities that have storage, that rent trucks. Typically, you often see them at gas stations, and the third most common is your self-storage facilities. The reason, and I think you've seen some of those applications in the last couple of years. One of the reasons that's popular is because, the self-storage believe that, if they have that ability, people will rent the vehicle, come back to them to rent self-storage. It's my recent understanding that one of the facilities that was approved in the township has already decided to abandon that use because it wasn't being supportive of their business because they needed somebody there all the time to maintain it, and they weren't getting the traffic to support that. The nice thing about this site is it always has somebody occupying it, and it's the same person who can service the U-Hauls. So I think I identified 5 facilities in the area. There are no standalone facilities, like full U-Haul facilities that are very large that rent many trucks. The nearest one of those I can think of is one we worked on in Ewing. The other sites include Hagen Tire, which is actually in Reddington. That's the closest one. And then you have, that's at a gas station. And then you have 3 other self-storage facilities, which is now down to 2.
Isn't there one across the street?
That self-storage, yeah, I think they have
No.
one. Yes.
The turnaround for Copper Hill used to be a Mavis Lumber or something.
Aaron or something, supply house, right?
Yeah.
Yeah, they have one there too.
I
And
didn't.
is-
U-Haul.
Oh, it's
Yeah,
not.
okay,
U-Haul.
it might not be
Oh.
U-Haul because I didn't see that on their
Yeah, it's
list of
not
sites.
U-Haul, it's
but
Oh,
something
so-
else.
yeah.
Which
Okay.
of the storage facilities have U-Haul?
I know it was Life Storage.
And Stowaway?
Stowaway was one, and I think there was one more. Yeah. Yep.
So which one had it that no longer
I
has? it?
think Life Storage is the one that's decided to not continue that. Yes. But point being is that, this is a typical use that you see at gas stations because of that convenience factor that it provides. And before I'll get into the planning, I'll just point out further that just to explain the signage, I think it was.
Just for the record, life storage, I don't want to testify. Tony, what do you know about the life storage U-Haul? Just for the record.
The Life Storage was arguing the case that U-Haul trucking would be as an accessory use instead of a principal use. And the planning board didn't agree with them, so they would have to come to the Board of Adjustment, and they didn't want to do that, so
But that,
they
that,
abandoned the use.
that pertained to Life Storage's new planned facility next door to the existing Life Storage,
Well-
not the existing Life Storage building.
They have U-Haul trucking now
They do.
illegal.
They do, but it's
Yeah.
the new building. It has been approved by the planning board that was not allowed to have U-Haul.
Correct. But what Tony's saying is, once that happened to them, then they decided to not come to the Board of Adjustment on the existing one, and so that's no longer there.
Yeah, I was reading those decisions in advance and, makes total sense. I mean, if they were renting it for the facility, it's accessory, but as they weren't restricted to that, it was acting as a principal use. So, we are suggesting the same thing. This is a principal use for the site. Just to show the sign, it was noted, again, we have an existing sign that's 15 feet from the right-of-way line. It's obviously set further back because of the, generally large right-of-ways of the DOT. So that is existing. It is 25 feet in height, which is compliant minus that location. It is also over the allowable signage limit now at 112.5 square feet. Our proposal is not to increase the height in any manner, but essentially install the U-Haul logo below the existing signage, which would be, it's a 10-foot span, so we're bound to that. And the way the logo would fit into there would end up being 3 feet tall to add an additional 30 square feet.
Is that shown on sheet 3? You have a
Yes.
pylon sign?
Yes.
Yeah.
So those are our 2C variances for signage.
I understand that the 1C variance is for the signage area. The other C variance is to let the sign stay in its current location, which violates the setback.
Correct. The 25-foot setback would be 15. Yes.
I think it's 20 foot.
20.
setback.
Oh, excuse me.
20-foot setback, and we're at 15.
John, I'm looking at the time. We're at 10 minutes after 8. We always made a policy of stopping at the end of an hour. We've gone beyond that. We do have 2 other applications.
Now, you're not going to get booted. You're going to stop, you sit there, and if they pick up time on the other 2, then you can finish the application. But what's been happening is it goes on and on and on and on and on. You finish, and then the other people, they're out. And the other people, those are 2 homeowners cases.
I hate to do that to you, but that's the way we've been operating to be fair to the other people. So
Not going to argue against you if you want to be fair. But we do want to come back.
okay, good.
We're not going to leave. I don't think we have a whole heck of a lot more. I think we can get done.
Okay, continuing on. Second case is BOA case number 11-2021. The applicant is Jai Krishnan Pillai and Kelly Hall. The location is block 77.09, pardon me, lot 50, and the address is 7 Amwell Road. The application is the C variances for accessory structures and detached garage. I hope I did not mispronounce your name too badly.
No, you were fine.
Thank you. Is it Pillai? Pillai, yes. Okay, thank you.
Okay, so let's start out by getting everyone sworn, both of you and the board professionals again. So can everyone stand up and raise? Right, and our planner is not participating in this application, so it's the 4 of you. So do you swear or affirm that the testimony you will give in this application will be the truth, the whole truth, and nothing but the truth? Okay, so now you saw how the other one worked. And they're relaxed, you get asked questions, but just speak slowly into the microphone. So can you guys decide who's going to go first? Identify yourself and spell your first and last name for our board stenographer.
I'm Jai Krishnan Pillai, JaiKrishnan, last name P as in Peter, Illai.
Hi, I'm Kelly Hall, KellyyHall.
Jeff, could you give Kelly Hall one of your mics, please?
If they want, they can take the one off the stand and use that as well.
Okay.
So they each have one.
Jeff Vaccarella, Township Assistant Planner.
Tony Hajar, board engineer. Okay.
As Mr. Drill said, it's very casual. Please present your case in your own words, and we will ask questions once you're finished.
Sounds good. So myself and Kelly, we purchased the property at 7 Amwell Road in May of 2021. And after the purchase of the property, we came to find out about the violations regarding the zoning within the property. So we are here today to request C variances. So apart from the primary residence, we have 2 structures in the back of the property, as well as a structure coming up as you go up on the driveway. So we would like to, we're here to request variance for the rear and side yard setbacks on both on all 3 structures, aside from the primary residence. The 2 structures in the back of the property, we would like to request variances for the rear and side yard setback. It is supposed to be at 15 feet. We, as I understand, are well below that. And as far as we understand, those 2 structures have been a part of the property since it was built back in 1865 or so.
Okay, so I'm just going to chime in because before the meeting started tonight, I met with the applicants and I also consulted with Tony and Jeff. And the board professionals have come up with a concept. We ran by the applicants and they're okay with it. Obviously, the board would have to be okay with it, but the concept we came up with is as follows. First, Jeff, since you've looked at the records and you've been out there and inspected, in your opinion, does it seem to you that the 2 one-story stucco garages are in fact lawfully created pre-existing structures?
Yeah, based on historic arrows and township documents.
So in your opinion, what the applicant just testified to appears to be true, that the 2-story frame dwelling, as well as those 2 one-story stucco garages were probably built prior to 1900, correct?
1900, probably.
What year?
1957.
1957, right. Okay, now, can you give the board background about those 2 stucco garages so they can understand what they used to be used for and what they're proposed to be used for now?
Yeah, we, based on township documentation, it was used for accessory apartments, rental apartments. And we have documents from probably the 60s and 70s stating that. And they are proposing one of the 1-story garage for accessory structure and the other one for a garage.
So did they in fact remove certain of the fixtures that would be used if you wanted to have an apartment?
Yeah, the previous owner actually removed all of the apartment accessories, the bedrooms and
the kitchen?
Kitchen.
And so let me ask the applicant, what's left? You have a toilet in each of them or a toilet in one of them?
There's technically a toilet in each of them, but the smaller structure had the accident, which took out the bathroom that was in there.
Yeah.
So in our discussions, though, the applicant would be willing to remove the bathrooms from the 2 one-story stucco structures, correct?
Yes.
And what the applicant's argument in essence is the lawfully created pre-existing non-conforming apartment uses have actually now been abandoned. And they, by taking out the bathrooms, will put the death knell on that. The structure, the buildings though, the structures, in my legal opinion, are lawfully created pre-existing structures entitled to remain. So even though by proposing to convert them from apartment uses to accessory structures, they're becoming more in compliance with the ordinance. And since the structures are entitled to remain, quite frankly, in my opinion, I don't think the board could require them to be removed in any event. And the one-story frame shed, I think the applicant acknowledges, Jeff, your opinion is that shed's been there only 10 years?
Yeah, give or take 10 years.
So the shed is not a lawfully created pre-existing non-conforming structure. My understanding is the applicant would be willing to remove the shed just to shave off some hard surface coverage, because they also need a hard surface coverage variance, which is kind of on the high side, a lot higher than you've granted before, but you haven't had a situation where you've had pre-existing non-conforming structures. And in fact, my opinion is because they have pre-existing non-conforming structures, if they remove the shed, you could actually ignore the hard surface coverage overage because it's entitled to remain. And the only variances you would need to grant would be for the setbacks, which you grant as C1 hardship variances because they're entitled to remain in any event. And the only thing that you can't do, and this would be at the applicant's risk, part of one of those structures is over the property line. That's not for the Board of Adjustment. That's a private property issue between the applicant and the neighbor. You can't grant the variance. You can grant the variance to violate a setback. You can't grant the variance to go onto someone else's property. So you would ignore that, and if the neighbor ever complains to him, that's between the two of you. So basically, that's our proposed resolution of this application, but it would have to be acceptable to the board, and if it's not, then you'll just have to, hear.
Can
the
you just
application.
testify that you agreed to remove the shed?
Yes, we agreed to remove the shed.
Thank you.
I have a question. Those accessories, what's gonna be the usage for that? I heard you said one is gonna be for the parking garage. How about the other one?
Yeah, the northeast structure, which is the larger of the two, would like to use that as a garage. And the other one as just like a tool shed and to store some of our.
You had mentioned that there was an accident that removed one of the bathrooms.
Correct.
What about the second bathroom? You said that you intend to remove that as well. Is that correct?
That is correct, yes.
Okay, thank you.
Let me get it straight in my head now. We're gonna get rid of the shed.
Mhm.
And we're gonna keep the two buildings that have setback problems.
I'm not hearing that.
Yeah, Jim.
Jim, you got to go louder.
Sorry, my voice is weak tonight. Okay, let me go back. We're gonna get rid of the shed.
Yes.
Okay, and then we're going to, you want it variance cutting back.
They want
setback
a
from the
setback
property.
variance because the existing location of both of the garages violate the rear yard and side yard setback.
We're getting rid of the shed.
Yes.
No, they're going to remove that shed.
Okay, that solves that problem.
Right.
All we're left with are two other buildings, and they need setback variances for.
That's right.
And they're gonna eliminate the bathroom, so it's only gonna be a garage and storage.
Yes.
Okay, just want to get it all straight.
Any further questions? Steve, any questions from you? No. Anything further?
Not if you grant the application, there's nothing further, right?
Would someone care to make a motion? Or is there any discussion of this beforehand?
I'll make a motion that we go, when I just go through describing, we approve.
What type of timeline to remove the shed? Give them some time. Do you have stuff in that shed right now, the wood shed?
Yeah, just some, a lawn tractor and.
I assume you're going to
so on.
move that into the new
smaller one.
large shed that's going to be the
Correct.
northwest structure, correct?
Correct.
How much time do you need to move the stuff and then have the shed removed?
Probably 60 days at the most.
Give them 90 days.
Yeah.
John, we have conditions on?
Yeah.
uh,
Oh, yeah,
these-
look,
These are,
that's a good point. Why don't you go through your memo?
think everything has been addressed, but there still needs to be zoning permits that are applied for everything. And the mailboxes were already taken down, so that's taken care of.
So the removal of the bathrooms and the removal of the sheds, 90 days.
Correct.
And so what other conditions still remain other than what you just mentioned was no additional now, this is a condition, no additional structures, because we know that they're way over on hard surface.
Right.
What about
just looking.
14?
Yeah, Jeff, just go through the memo and say, by number, which of these numbers do you want as conditions?
Number 5,
Got it?
number 7,
Yeah, I looked at that. So what the existing says, the existing stone driveway is within 5 feet of the property line. The applicant is requesting a non-conforming use certificate. Historic aerials provide the location as being consistent with the existing layout. However, all gravel shall be located on the subject property. Explain what you mean. You mean there's some gravel on the neighbor?
yeah, the plan of survey conducted by Jeffrey T. Baldwin shows some gravel on the adjoining property.
Condition, remove any gravel off your neighbor's property. Acceptable?
Acceptable, yeah.
What else you got?
Number 9 is more of a question of if there's utilities.
That's a good point. Are there any utilities? You're taking out the bathroom, so there's going to be
Correct.
no plumbing. Obviously you have electric in there.
Correct. Both the sheds have electric lines going to them and they have baseboard electric heat.
And there's no prohibition against that, right? Okay.
Are you gonna have air conditioning or not?
No air conditioning, no.
Do I need to make that a condition? If he wants to put air conditioning for his cars in the garage, do we? Okay, all right. Any other numbers on this thing should be conditions in either of your opinions?
Number 10,
Yes. So the garage is going to have no more than 2 vehicles owned by the primary residence only. And the garage is for residential accessory use only, and that condition will also apply to both of the structures. Agreed?
Agreed.
Any others?
What about 14? 14?
I was going to say 13 and 14. yeah.
Okay, so explain. I understand 13. They need zoning permits. Explain, and we're crossing out the 1-story shed because that's being removed. Explain 14. What do they need to do?
They have to apply to the Hunterdon County Planning Board, and they have to review it because it's on a county road.
Okay.
What do they have to apply for, Jeff?
Wait, but it's a single family home. These are now accessory structures. So they're exempt. I believe they're exempt from, if they apply to the county, I think they're gonna get an exemption letter. If they were apartments, multifamily that have to apply. You agree?
Yeah.
Okay, so I'm gonna cross out number 14.
Good.
So it's 5, 7, 10, and 13, correct? Okay. Okay, thank you, because I would have forgotten about that. So those would be the,
John, would you please restate those conditions?
yeah, so in addition to removing the shed within 90 days, removing the bathrooms in the stucco structures within 90 days, they are going to, there's going to be a condition, no additional structure shall be installed on the property. And I'm going to say, in light of the fact that the impervious surface coverage is, it's no longer 38%. I asked Tony to do a calculation. If they remove that shed, what's the?
37.43.
All gravel from the existing stone driveway shall be located on the subject property, and any and all gravel on neighboring lot 49 shall be removed. The northeast structure, which shall be used as a garage, shall house no more than 2 vehicles owned by the primary residence only. And the garage is for residential accessory use only. And the northwest structure shall be used for residential storage only. And then the last condition is zoning permits shall be applied for and obtained for the 2 detached accessory structures, not just the garage. Okay.
Okay, Mr. Ferraro, would you like to amend your motion in light of the conditions that were just stated? Yes. A second?
I'll second.
Amy?
Zoning Board Chair, Mr. Roger Aaron's.
Yes.
Mr. Kevin Cool.
Yes.
Miss Cynthia Schaefer.
Yes.
Mr. Randy Block.
Yes.
Mr. Steve Farcia.
Yes.
Mr. Jim Ferrero.
Yes.
Mr. Brad Perry.
Yes.
Okay.
Thank you.
Thank you.
Thank you.
Take a break.
Let's take a break. It's 8:30. We'll be back in 10 minutes. Like to call the third case, which is BOA number 6-2022. The applicant is Nicholas Caracappa, excuse me, block 37, lot 2, 14 River Road. The variance for expanding a residence use in the O2 zone and encroachment into the preservation of natural features buffer. Caracappa?
How you doing?
Okay, so let's start out. You've seen the other 2 applications, so you kind of see how the board operates. So the first thing I'm going to do is swear everyone in. So who's participating in this application? Just you guys, you 3. Huh? No, and him. Do the 3 of you swear or affirm that the testimony you're going to give in this application proceeding will be the truth, the whole truth, nothing but the truth? Okay. Slowly and into the microphone, identify yourself, spell your, Nicholas is easy, but spell that last name for our board stenographer.
Sure, no problem. Nicholas Caracappa, C-A-R-A-C-A-P-P-A, 14 River Road, Raritan Township.
Jeff Vaccarella, Township Assistant Planner.
Tony Hajar, Board Engineer.
Okay, so take it away.
Caracappa?
Sure. I'm here because I have a shed that my father-in-law built on my property, and we do not have permits for that structure. So I received a notice in the mail, and I'm here to apply to get that approved. While I was going for that approval, I also thought, well, since I'm paying all this money for application fees, why not throw an addition on the house as well? Make it a little more easy to follow, since I figured I was gonna have to come back and do that anyway. So I'm here to try to get approval for both.
Okay, now, this is what I want to find out from,
Into the mic.
this is what I want to make sure that I understand. I understand about the relief for the shed. Explain who's taken the position that this should be a D2 expansion of a lawfully created pre-existing non-conforming use versus a D1 use variance for the addition. And I'm asking either Tony or Jeff, since it's in your memo, first comment.
We did, yes.
Yeah, so
Explain why?
Yeah.
Because the property is in the O2 zone, any expansion of anything will require the D2.
In other words, if there's a lawfully created non-conforming use that wants to expand, it's a D2 and not a D1. What information do you have on whether or not the one-story dwelling is in fact a lawfully created pre-existing non-conforming use in the O2 zone?
Based on aerials and tax cards.
And so, in your opinion, it was when and what was it zoned for at the time it was constructed?
It was constructed prior to 1965, which the O2, the residential zone changed to an industrial zone. And it was you just wanted to know the zone and the construction, yeah.
So, except from what you just testified to, I agree with your opinion as the township assistant planner, as the board attorney, that if the dwelling was constructed prior to 1965, which based on your review, it was.
John, can you get a little closer to the microphone?
Yeah, if the dwelling was constructed prior to 1965, which Jeff is convinced after reviewing all the documentation, it was, then at that time it was constructed, the property was zoned residential. Therefore, once the property changed from residential to O2, in fact, the dwelling is a lawfully created pre-existing non-conforming use. So to expand it, he doesn't have to meet the stricter D1 use variance standard. He only has to meet the less strict D2 expansion of lawfully created pre-existing non-conforming use standard. That's the first issue. The second issue is, it looks like the two additions also need setback variances. Is that correct? I know that the dwelling right now, it looks like it's grandfathered, but it looks like the additions are going to be a further encroachment. Am I correct?
Yes, sir.
Okay. And the shed is a residential. Can you tell the board what's going to be the use of the shed?
Well, originally, my property is right on the Raritan River, the south branch of the Raritan River, as you can see. And we like to use the river and go canoeing, boating, things like that. So originally, the shed was going to be to house and keep boating stuff, keep my kayaks, stuff like that down there. And then also as like just a general storage of, residential type things. No utilities are going to be provided to the shed. Just storage, pretty much.
Okay, but the problem with the shed location, for the record, who wants to explain?
Is the shed location is within the 75 feet, no disturbance, and 100 feet, no structure of the stream.
And again, I advise the board. I don't speak for them, but from what I know about them, that is going to be, am I correct that that's going to be a problem in this application?
Yes.
In fact, John, the environmental report, I don't know if that's relevant for this.
Yeah, it is.
Yeah.
And so you've seen the environmental commission's report, which was dated May 24th.
I have it right here.
So, let me ask you this. How is the shed attached into the ground? Tracy, lift it up.
John, I'm really not hearing you, John.
Sorry, that's because Tony grabbed the microphone away from me. Set me up for a big one. Could you lift up the wood shed and put new footings or foundations that are more than 100 feet away from the stream?
That is my goal. Can I personally do it? I
You
don't
get
really.
someone to do it.
I'm gonna need some assistance.
So
but that's my goal.
my suggestion is that you do that, not remove it yet, but get a plan showing where you're gonna put it. Hmm?
He's got that, John.
He does.
Oh, I see.
He's got it.
Okay, he's got it.
Sorry.
I
should've-
mistook. Okay. Okay, so take it away from here then. Where does it show where the shed? Oh. My apologies for that.
Tony, does the new location solve the problem with the violation regarding its current location?
That's correct.
Are you willing, you say you are willing, obviously, to hire someone to do this for you?
I am.
Okay.
And does he need any, like, temporary relief to let someone go back in there and disturb to move the thing, or just?
He's gonna need
He's
that
gonna need to-
75 feet, no disturbance, variance.
Not hearing
Can
you,
you tell-
Tony.
That's because I got the microphone now.
I'm sorry.
Tony said he's gonna need a 75-foot no disturbance variance to actually take the shed out of its current location so that it can be moved to a compliant location. Which sounds like a C2 variance to me. Now, you guys have, Art, Tony and Jeff, you've read the Environmental Commission's report. Take a quick read, and I'd like your opinion on if the shed is moved to where he's proposing to move it to. Do you think that would satisfy the report? Because what they're saying is the only way to determine if the proposed structure.
Sorry, Jeff, I didn't hear you.
The plan doesn't distinguish where the wetlands are. So where he's proposing it, there could be potential wetlands.
How can that be best be corrected by Mr. Caracappa? He's going to have a study done,
Yeah,
wetland study?
yeah, and verified by the state.
Just a quick question. How do you determine, I know there's a stream there, there's a river, but how do you determine how close you require these wetlands studies to be done? Like how far off would it have to be for you to feel comfortable that I wouldn't have to do a wetland study?
That's a question. Can you answer that?
Yeah, I mean,
Well, what could you-
we don't know where the wetlands are. That's
But
the
you could
issue.
say that for any
You're gonna have to,
property.
if you contact an engineer, you have to, that question is to contact an engineer. And I'm not suggesting anyone, but for example, Mr. Ingram was testifying on the other case. Why don't you just go out in the hall, tell him your issue, ask him.
Well, it's more to you than to him. I'm asking you, what makes you throw up a red flag for me to say this land here might be wetlands? Like how far, because I'm assuming you don't always say that to somebody if they're moving or
No,
constructing a piece of property.
we looked at GeoWeb and it shows wetlands. And again, GeoWeb is not an exact science. It's
Right.
not an exact thing. But the way to do it is basically you hire a wetland specialist. He will walk the site and flag where the wetlands are.
I
And then you-
understand that.
Yeah, I'm sorry?
I understand that.
He wants to know why why are you making them do that? Explain the significant, if you move it and then it's illegal to have a structure in a wetlands or in a wetlands transition.
Yeah, that's
So
correct.
if you think you're in trouble here, if you get in
I
trouble with
understand.
DEP, you're in big trouble.
I understand.
So what they're trying to help you out by saying, listen, you could be here and the board can grant you an approval, then you go put it there and your neighbor or someone calls the DEP on you. And if you're in a wetlands or a wetland transition area, you're gonna have to move it again. It's gonna cost you a lot more money than being here.
Many of the cases that come before us, probably 30–40% require a wetland study. And even Jeff and Tony can tell you that we have a major corporation that's been before us for a long period of time. You know which one I'm talking about, where the wetlands determination took a while for them to actually get it. And yet, if you were to look at that property, you wouldn't guess that there are wetlands there, but there are. So, we're not asking you to do something that's unusual. This is fairly common, especially since you border on the river.
Yeah,
So-
I'm just trying to get a gauge as to how it's determined based on the property. I know it's close to the river, but I didn't know if there's a certain distance from a stream for.
Yeah, it's
or-
not the distance,
not the
believe me. It's the elevation
Features.
more often than not. And Tony and Jeff can tell you more about this.
Well, I'll cut to the
As a
chase.
rule of thumb, if you wanted to be, not gonna say safe, if you wanted to make an educated safety guess, if you assumed that the wetlands were the highest value wetlands, the requirement would be 150 feet. So if you moved it 150 feet from the stream, you're probably safe. But if you wanted only 127 feet from the stream, and again,
It to be more than 150 because
it could be a
usually
transition,
the wetlands is not against.
right?
I see. Now I'm understanding. Okay.
So you'd get someone
So-
to go out there to, first of all, there have to be some wetlands
Right.
out there because you have a stream going through. it.
Gotcha.
So you get someone to
There's
go
a
out
buffer
there.
off the wetlands, not just the stream.
Right.
Right.
And,
Got
and the safest thing is if you go 150 feet from the wetlands, that assumes it's a high value wetlands, but then if you pay a little extra money, they will determine what value the wetlands
Right.
is. Is it high value, intermediate, or ordinary? If it's ordinary, it's 50 feet from the wetlands. If it's high value, it's 150 feet from the wetlands.
Okay. So then, what if I move that shed to where the coop is located? The coop's looking in rough shape. What if I just knock down the coop, replace that structure
Okay,
there?
just so you know, there's a thing called isolated wetlands.
Yeah,
Listen, don't be, this is just, I advise the board, I'm not advising you, but you know the expression penny wise and pound foolish?
yeah.
If you just move it to the coop and they're like, okay, yeah, we'll do, at that point, do they even need a variance for the shed? Well, it's increasing the intensity of a non-conforming, so you put that under the D2 variance part, let's say they granted it.
Mhm.
And then your neighbor, you get into a dispute, how these things happen a lot. You saw everything tonight. It's, the zoning officer doesn't drive around in his car like with a flashlight at night, checking for zoning violations.
That's
He's
why
not a
I'm wondering
roving-
how I'm here right now.
He's not a roving zoning violation checker.
Well, how am I here?
Okay, well, someone called.
Who?
Well.
I want it on record.
Mm-mm.
Who called?
That's confidential, but I can just tell you that people call, when they call him, he's got to check. When he checks, so if you move it to where near the coop,
Yeah,
and they say yes, and whoever you pissed off and you don't even realize you pissed them off, calls, and then they go out and they find out that you have isolated wetlands, again, you got to decide what you want to do, but the safest bet is to get an engineer to go out and map out where your wetlands are, and to tell you what value they are. Then you know you could be safe, but it's going to be up to you, because I have a feeling if you said you wanted to move it near the coop, they might say, you know what? all right, no skin off our back. I don't know if they say that, but if they did say that and something goes wrong, don't blame them.
Yeah, I would.
So you got to decide what you want to do, but right now.
I'm asking if you'd be okay with me moving it to where the coop is located. And the coop, if you know my property, is much higher elevation. I think Jeff was out there. I don't know who went out there, but my property has a very steep elevation from the river.
Mhm.
It's not. Anyway, I mean, you guys probably all know my property. Everybody knows my property.
You said that you're gonna store canoes and kayaks,
Yeah.
but if you move it up here, it's
I gotta store them somewhere. Right? So
They
I'd
make
probably
these big
still
rub- they
use
make
it for the
these big
same
rubber
thing. It just
wheel
wouldn't be as
things where you can
convenient.
wheel the canoe and kayak down to the river.
Yeah.
They use them at the beach too, over sand. If they use them over sand, he can use them, he could use that in his yard.
I mean, the other option is you could hire a wetland specialist to look at the site and give us a presence absence report stating that in that.
How about that,
location.
Tony?
Starting in.
And you could hire a wetland specialist to evaluate the area where the chicken coop is and write up a report stating that there's no wetland within 150 feet. And that will satisfy that.
And if he did that, if he did that, and there was no wetlands, does he need any variances?
Well, there's gonna be.
See.
Variance report. I'd be shocked if there's no wetlands near the stream. What Tony is saying is hire a guy to look only around the coop area.
Right.
That would reduce his cost. And then if Tony got a letter, no, there's no wetlands, he doesn't even have to go to the DEP.
Right.
Tony will rely on that.
Right.
That's how, if you wanted to go to the coop, that's the least expensive way to go and know that you're gonna be safe. Have that feel comfortable also. You should, first of all, turn that thing on and address all the comments.
Not on Jeff. Now you go.
But if he goes to the coop, does he need number 9?
Does he need a variance if it goes?
no, comment number 9 is referring to a conservation easement.
The ordinance requires.
Yes, the ordinance
He
requires
would have to
that.
seek an exception for number 9. That has to be a condition unless he seeks relief. from it. That's what the ordinance says.
Okay, but now you just confused me, because if he
Yeah.
goes to the coop and he has the wetlands expert just go around the coop to lower the cost,
And we don't know where the wetlands are.
Yeah,
right,
then
then you
he
don't know
still
where
needs
the
to know what-
wetlands are, so now he's got to do that, and that's got to be an easement, conservation.
Not hearing you.
What's being discussed is comment number 9 in Jeff and Tony's memo dated May 27, 2022, notes that all areas comprised of floodplain, riparian zone, preservation of natural features, wetlands, and wetland transitions areas have to be subject to a conservation easement. So what Jeff is correctly noting is, while Tony's idea of lowering the cost to the applicant by having a presence or absence letter for wetlands around the area of the coop does not eliminate the fact that it looks like he's going to have to, if he wants to get any approval from the board, he's either going to have to seek an exception from the requirement in the ordinance that number 9 is based on, and then you're going to have to prove there's some reason for them to grant an exception, which can't be financial related. It can't be because it's going to cost you money to get the wetlands mapped. So he's going to have to get those wetlands, at least around the stream, mapped in any event. That's what Jeff's point was. And you know what? Unfortunately for you, Jeff's right.
So
you could get the wetlands mapped around the stream and then get an absence or presence around the coop. So the guy doesn't have to do the whole property. It's going to map them around the stream, give you absence or presence around the coop. Or wherever you want to propose moving moving the shed.
So if he does the wetlands expert, and he says, I need to know around the area, the wetlands. The expert would then by note, tell him what's not.
If the expert does the whole property, correct. If he wants to lower his cost, he could tell the expert, map my wetlands along the stream. Don't do the whole property, but give me a presence or absence near my coop. That would be lower cost than mapping the whole property.
And this is to do any type of, if I come in here for any type of application, I would have to get that done. Is that correct?
Well, put it this way. If it weren't for the addition, I'm not so sure. Probably, but with the addition, absolutely.
So,
I mean, with this type of shed, probably the answer is, yeah, you have to. You know, we're not talking about like an 8x10 garden shed. This is what's the dimensions of your shed? Saw the pictures, it looks very nice.
it's like 12 by 14, I think. It's not that big.
Yeah.
It looks big, but.
Looks like a cabin.
12 by
It
16.
doesn't look like a
It
shed.
does.
Looks like a hunting cabin.
Yeah. It's a shame.
12 by 16.
12 by 16. Okay.
But the view on the inside looks like a man shed.
Yeah.
Yeah.
Well,
Yeah, I know.
okay, so I know this isn't relevant to this application, but I'm just curious, did Northlands have to provide you with a wetlands map for any?
Oh,
work that
Northlands?
they-
Oh, yeah. Oh, man. Yeah, Northlands also was subject to about, I don't know, how many months of hearings.
Any idea what a wetlands map costs for a 10-acre property?
A guy out in the hall would probably know.
I'm already in $5,200 for a shed.
Listen,
That doesn't even
you
cost
ready
the
for this?
money
That's
to build the
why,
shed.
that's why ask first before you do. That's the moral of the story.
You have a father-in-law?
Tell your father-in-law the moral of the story. Now, how many years have you
I
been
can't.
married?
He'll have a heart attack.
Okay. Anyway, my suggestion is seriously, take a 5-minute break, go ask Mr. Ingram in the hall, tell him the situation and ask him to ballpark.
Well, that's all right. I mean,
Okay?
it sounds like that's what I'm gonna have to do, right? So regardless of the money, I mean, can I get a conditional approval of if I move the shed there and get all this done?
Now, they got to see it. They got to see the thing where it's proposed on paper. They need to see the report from the wetlands guy. They have to know before they would grant the relief that the thing's not violating, for them to do their due diligence. They don't want to approve
We've
something. and have it-
never approved anything conditionally like this.
Sure,
Yeah.
okay. So then I guess there's really nothing that we can be decided tonight.
Correct.
Yep.
Well, I'd also like to bring up that if he's going to apply for an addition, there's a lot more information that needs to be provided.
Absolutely.
Okay, you know what?
Drawings, everything,
Yeah.
and we don't have that at all.
Nothing.
So my thinking was I was just going for, I would absolutely provide that. I was just trying to get the approval for the boundaries of
Right,
the
but here's the
addition.
thing, because it's a setback deviation,
Yeah,
they're gonna wanna see, I mean, look, you know that you're gonna make the thing look nice. They have to assure themselves that it's gonna look nice, it's gonna be closer to the street than permitted by the ordinance.
Well, and you also haven't defined whether it's, you're gonna add bathrooms and the well situation and.
right.
And the
So-
septic, they have to dot the i's and cross the t's, but to put them in a position, listen, I've been representing this board for more years than you'd actually believe. This is one of the more liberal variance granting oriented boards of all the boards I represent. That's not a criticism, that's just a fact, okay? But they want the i's dotted and the t's crossed before they grant one, because they don't want to, if they grant, let's say they granted a variance and there's nothing in there about that you were adding 3 bathrooms. I know you wouldn't be adding 3 bathrooms, but and then you go and you add 3 bathrooms. And there's nothing in there about the addition has to look like, the rest of the house, so it doesn't look like it's an add-on. And because there's nothing in there that says that, you come up with this crazy, ugly-looking thing. They grant the variance. Now the neighbors aren't going to be, besides yelling at you, they're going to be in here yelling at them. The township committee is going to be saying, what's wrong with you guys? Didn't you do your due diligence? These guys, they do their due diligence.
So I have to put together a full set of plans?
You don't need a full set of plans. You need
Before.
elevations and you need a floor plan. In other words, you don't need construction documents. You don't
Okay.
need documents that you can give to a contractor. You need an elevation, what it's going to look like, floor plan, what are you proposing inside?
Okay.
Hey, Tony and Jeff, you guys will help him, right? Figure out what is needed. Can you provide that support? Like just
Well,
tell him what's needed?
I think he's gonna have to he's gonna have to pay an architect to get the elevations and the floor plan, and he's gonna have to get a wetlands specialist for the wetlands.
Perfect. Okay.
So why don't we, hold on one second. Did you check the certified mailings on this one? Okay, so why don't we just say that the board has procedural jurisdiction over the application? If we can agree on a date to continue this to, we can at least save you from having to renotice. We could carry this to a date certain without the need to renotice. Now, you might want to put it off for a while, but look, no one from the public has come in any event. So it's not like some of the other applications where 10 people are here. And then if you put it off 90 days, they start to complain that that's too much time. They're going to forget. There's no one here. So how much time do you think you need to get the floor plan elevations and the wetlands information so that you could have a revised plan on file with the floor plan and the elevations, which has to be on file 21 days before they hear it? How much time do you think you need for that?
I would think 90 days.
Okay, so why don't you check the calendar 90 days out? And let's give them a date certain right now so it can be carried without need for further notice.
You could have August 4th or August 18th.
That's only 60 days. If you want to go 90, I would go September.
What do you have in September?
We got June, July, oh, okay, August.
Right.
September 1st is the first meeting in September.
September 1st or September 15th.
You have a preference?
First sounds good.
Okay, so this, and when just, the board has 120 days to decide a variance application. When was this thing?
John, that's a lot of work to get done by September 1. Don't you think the applicant would be better served by going for the 15th to give himself the amount of time that he needs to get the work done?
The application was due complete on May 5th.
Right, so here's my suggestion. If he wants September 1 and he's not ready, that's gonna be his problem.
Yep.
Then it'd have to be carried again. You want September 1 or September 15th?
Does that work with what your dates from when I
Yeah,
submitted?
because we're gonna ask you to consent, whatever date you want this thing heard at, I'm gonna ask you to consent to extend the time the board has to decide the application for 60 days beyond that. So whatever date you choose is gonna work.
Just keep in mind, engineers and architects are really busy.
Yep.
Okay,
So-
give me the 15th.
Okay, so
I have a question, Tony.
let me just make this announcement. The hearing in this matter is going to be continued without need for further notice to September 15th. And the applicant agrees to extend the time for the board to decide the application to November 30th, correct? That's from the app. You extend the time they have to decide it to November 30th?
Yes.
Okay, go ahead, Jim.
I have a question, pardon me, I have a question for Tony. Tony, if he called you, could you give him some concrete direction? This is what you need to get.
Yeah, we just did, but yeah, if he
Okay,
calls
because
me,
we
yeah.
have- I could tell he still doesn't know what you want. Okay, so wetlands delineation is what you're looking for, am I right?
That's correct.
All right, so, I mean, if you call him, he'll give you some good direction to where to head, to get this thing done.
Thank you.
Right, Tom?
Yep.
Thanks.
All set?
Yep.
Thanks, guys.
All the other tracks?
You make it quick. Amy, you want to stop the recording for? We're back in session. Mr. Grunberg?
Mr. Ingram was in the middle of giving us the benefit of his engineering testimony.
And I apologize that we had to interrupt you.
The last thing he was on was the signage thing. I just want to make sure I get this straight. The maximum sign size is 100 square feet, correct? Correct. The existing sign is 112.5 square feet. Correct. The additional piece of sign is 30 square feet, so that would increase it to 142.5 square feet. Correct. And the setback required is 20 feet, the current sign is 15 feet. All right, now I understand.
So I have a question on that. I think you said you were compliant in your testimony about that.
The height was compliant, the existing location is not compliant, it's not proposed to be changing.
I can't hear you. I'm having trouble hearing.
Still on?
No, it's not on.
Not on.
So the height is compliant, the location is not, it's at 15 feet currently, where 20 is required. That was previously approved in that location, and the size is slightly larger than what's permitted. So we're going to be increasing that a little bit further.
So John, I read this morning about the previous resolution, whatever you guys had shared with us.
Right.
And there was something about compliance of that sign. Can you please help me understand that?
Let me see if I could. You're talking about the resolution 18-2000 that I referenced before. correct?
Yes, indeed.
Wayne, while John is searching for that, one of my board members asked, where is the billboard located? Can you please show us that?
It's on the western portion of the site, about 20 feet south of the exit drive.
Is that,
Okay.
is that shown on the existing plans or not?
It is, yes.
Okay, what sheet are you on?
I'm on 3.
Can you just come over and just point it out to me in my plans? For whatever reason, I'm having trouble finding it. Aha.
No, the billboard.
I'm sorry.
Yes.
I thought you were referring to the bigger site.
No.
Yes, the billboard is right there.
Okay, could you show us on your,
It is in the northern, northwesternmost corner. I apologize. Right there.
thank you.
Okay, I have found in resolution 18-2000, finding number 41, which starts on page 6 and goes to page 7, says, the signage which has been proposed for this facility complies with all ordinance requirements. Now, Jeff, do you know, was this 100 square foot signage requirement changed since 2000, or has it always been 100 square feet since 2000? Microphone. Okay, so. There you go.
It's always been 100 square feet.
All right, so this is, so that sign's not grandfathered. That sign looks like it's.
The extra 12 and a half feet would not be permitted, correct? I don't know the history of why it is or isn't, slightly larger than what was proposed.
To get it down to 100 square feet, before we even talk about adding the U-Haul sign, I'm looking at the pylon sign detail on page 3. I see a section under Liberty which has cross-hatched in it. If you eliminated the cross-hatched portion, would that sign come down to 100 square feet? Yeah, and measure that.
I would say yes. It's slightly slightly taller than a foot and it's 10 feet across. So it's got, 10 by 1.25 would be, so maybe that just wasn't counted as part of the sign. Yes.
So that's so you could get the existing sign down to 100 square feet. So now the question is, why does the U-Haul sign have to be 30 square feet? Why can't the U-Haul sign be, I know you can't reduce the length because that's where the two support, the width, because that's where the two supports are, but why can't you decrease the length, the height, thank you, of the sign? Why does it have to be why does it have to be 10 by 3? Why can't it be 10 by 1.5?
I'm not saying that it can't. What we're suggesting in terms of the variance is, number one, we don't want to certainly propose a second sign. That's not going to help us in terms of
I don't think they
compliance.
grant the second sign, but.
Right, I agree. But, we want to make sure that it's large enough that it could actually be seen on a highway.
Let me ask you this, though. If the applicant's principal testified that this is not going to be like a drive-by facility where people are going to drive by and go, oh, I want to rent a U-Haul, oh, I'll go in there. This is done by computer, and you put an address in, and everyone and their brother, right, has a direction app, so they put the address in. Why do you need the sign so big?
She actually did testify that one part of the business is people who do drive in and come in either by phone call or drive in and rent vehicles as well.
I understand.
So it's not, so it wasn't just
Okay.
computer generated.
Put it this way.
Part of her testimony was that they do come in.
I would argue that there are a fair number of GPSs that doesn't matter what address you put in, you might not know exactly where you're going. It
Right.
might not be accurate.
Let's
So
do
the
it
point-
another way. Do you need the sign, in your professional opinion, to be 3 feet in height in order to make sure someone doesn't miss this location for U-Haul?
That is what we're suggesting.
No, I know that you're suggesting. I'm asking your professional opinion. Do you have expertise to be able to testify that someone driving by the site at whatever the speed limit on the road is needs a sign to safely identify the facility to be 3 feet in height?
Yes, and I think that's supported by, if you look at the sizes for the other components of signage there, we're basically trying to match those. And except in this one, it's even going to have to be lower.
So let me ask you this, why can't then all the components be reduced in size so you have a 100 square foot sign instead of a 130 square foot sign?
Well, to some extent, I feel that it's somewhat wasteful to take an LED sign that's existed. It harms no one. It's at a compliant height, and to have to demolish all that for the sake of reducing the square footage slightly, when we don't really have any impacted properties and we're just trying to make sure that the sign can be seen, I don't think it's worth the waste that that will occur for this.
So that's what
minor
you
deviation.
guys have to decide.
Yeah.
John, John, the speed on the highway, I'm tending to agree.
Right, just put it this way. Don't take my questions as I'm advocating a position. I'm just asking him the questions. You guys will have to decide.
And I guess that's the question with the location of this is not on Route 31. It's on.
Right, this is
202.
certainly a busier section. And, again, I was going to get into variances, but, related to the C variance with the distance, number one, the 15-foot setback exists.
Yeah, but that's another thing. If the sign was compliant, how did it get to be 15 feet? Why is it not 20 feet?
I don't know the history of what.
Jessica Caldwell?
There you go.
Okay. The ordinance for 100 square feet or less permits a 15-foot setback. So that would have been a compliant setback for a 100-foot square foot sign.
I bet that hashed part is the answer to.
The size
They
question.
probably didn't
The
count
hatch
it.
part is American flag.
I
And it's part of-
understand, but. Yeah, but I understand that.
Hey, Jessica, I just want clarity there. What you're saying is if it was 100 feet, then 15 feet is okay.
That's what Jessica says, the ordinance says. Yeah.
However, they're asking for 140 plus, right?
Yeah. So the requirement, so just assume for argument's sake that, let's say you can make an argument that because the hashed part of that sign, which Jeff just told me is in fact is an American flag. Let's assume that you could exclude the American flag from the calculation of the square footage of the sign, for argument's sake. then you would have a 100-square-foot sign, which would in fact comply at 15 feet. Once they add the 30-foot, now they need two variances, one for the size and one for the setback, because now it's no longer 100 square feet.
And the upshot is that's what we noticed for, which was for a 30-square-foot addition to the existing sign and the two variances that would necessitate.
John, I don't want to side with, the applicant, but this location is isolated. It's got a lot of trees and everything around it, and everybody goes about 70 miles an hour in this section. So I would be hesitant to minimize the signs just to fit in. I think I'm okay with them asking for a variance.
Why don't you guys straw poll right now?
Do you want to hear the planning testimony with respect to
Well,
this sign,
listen,
or?
If you want to hear a straw poll before the planning testimony, you can. You
Uh,
might be very
Okay.
happy with the result.
Okay.
Maybe you won't be, then you could put on the planning testimony.
Okay.
You want to straw poll people on what they feel about, are they okay? And again, I'm not suggesting one way or the other. If you are okay with it, because like Cynthia says, isolated location, a lot of trees, it's on a highway, you could then say, if you wanted to grant the variance, C2, there is no hardship, okay? Because C2 and the basis of the C2 would be, because it's isolated, because it's a lot of vegetation, because it's on a highway, it needs to be large to make sure that people can safely see it. Now, if you think that no, aesthetically, the thing's too big, whatever, then you could say that, well, yeah, if you were going to grant it, it would be a C2, but, then you'll have to hear based on testimony to see what Wayne's experience has been, how he knows the site distance with this. There's actually a formula I've heard traffic engineers use based on the speed, based on the site distance, how big the letters have to be and all that. Maybe he could then give testimony like that. But why don't you straw poll to see if we have to go into that detail or not?
Before we do that, I have a question. Did you say this was an LED sign?
I believe the numbers in the change
Is
in
it
gas
lighting? I
prices.
guess that's my question. Is it lighting?
The numbers are, yes, it's a lit sign. It has multiple sections telling you the prices that change, with the change.
This would be the price of the gasoline. Is that what you're
Correct.
saying?
Yep.
Okay. Do you want to do a straw poll?
Yeah. Why don't you start on one end? We'll start on this end to see how people feel. Or just before you hear the testimony, are you inclined to say, yeah, you'll find some reason to grant the sign variance, or your first reaction is no?
My first reaction would be no, because I want to understand more about why it's that big. I'm
Okay.
also concerned about precedents it's going to create. So 2 months later, somebody else can come here with sign somewhere else, and they'll want 140. So I really need to understand why.
Kevin, straw poll.
I don't have an opinion yet. I want to listen to more.
Oh,
But here's a
okay.
question. Can I ask a question now?
Yeah.
How is, in the 30 square foot, what's the square footage of the Liberty sign? Do you know offhand, Wayne?
I would say slightly smaller. Again, it's not the internals. I don't have 100% scaled, but slightly smaller. It's comparable to the sizes of the numbers for the gas prices.
You know my opinion.
Yeah, she's a yes. So I have not sure. I have a no, a yes, a not sure.
Okay, the reason that I'm saying yes is because of the fact that this property sits below the elevation of the highway itself. This is a difficult property to see down in. It's not up above or at the same level, it's below. Therefore, I think the signage is necessary in order to see that it is the U-Haul
You're
facility.
saying this, not that just the signage is necessary, the larger size of the signage is necessary is what you're saying.
Correct. Yes.
I have no problem with the size as long as we stay at the 20-foot setback.
But you can't.
You can't.
It's already there.
It's already there,
there.
at that 15 feet.
The
They're not-
size already-
At 15 feet, they're not willing to
Yeah,
change
the
that.
U-Haul is not there. The sign itself with the gas and everything, that's already there. We're just trying to tack it on to the bottom of what's already there. We don't want to have to rebuild the thing.
And I think 100 square foot sign would do it.
So you would want, so you're no, you would want them to reduce the size of the sign,
Yeah.
okay?
I'm a no right now because, again, it's a significant increase over the permitted size. And plus you can potentially have 7 trucks with U-Haul written all over them. And
You can't see them.
I'm a yes for the reasons already stated.
I mean, yes, also. One thing I want to bring out, Herring Glen, the golf course that's right next to.
Microphone.
Oh, I'm sorry. Herring Glen is right next to the gas station, and it has a small sign. I've missed that many times. I also have gone to that gas station and I've missed it also because of the signs. So I'm a yes.
Okay, so it's a close one, but.
John,
Oh, forgot, yeah, sorry.
Yeah, I'd like to comment on this because I think the people who voted no need to really understand this situation here. I've actually used this service and I missed it not once, but twice as to where the U-Haul was actually at the facility. This location is exactly what Cynthia said and Roger said. It is a perfect location for this type of use. The sign is not going to make a difference. It's only going to help the residents and people who need to come there to rent these vehicles. I'm telling you, I missed it myself twice. And all we're talking about is adding to the bottom of the sign. This is a perfect location for this, and it's needed. This is, you're basically guessing at this point in time when you're driving. You do not see the vehicles, by the way. So whoever said, oh, you're going to see the vehicles and you'll know it's a U-Haul place, you're not right. That's wrong. So this is not something that they're trying to pile on. This is something that they need. And to be honest, this is something that the residents need. I don't know why this would be such, I don't even know why we're arguing over this, to be honest. It's a C2 easy.
Okay, from my count, even though the straw poll was 5 yes, 3 no's, and 1 not sure, the 2 alternates were no's. So the straw poll is actually 5 yes, 1 no, 1 not sure. So why don't you just put your testimony in just to dot the i's and cross the t's, but now that you've heard a straw poll, you might want to make sure that you get the testimony in to hit some of those points.
Sure. Yeah. Mr. Ingram, why don't we talk first about the D1 variances and how this special reasons for granting is.
Sure. That's fine.
So are you going to planner mode now?
Yeah, I was basically done with the engineering.
Okay.
phase, Unless there's any questions.
Are there any questions on the engineering?
Yeah, I want to just follow up. One of these truck spaces is parked right in front of the billboard, right? Is that wrong?
We were proposing that,
Yeah.
but based on the comments we received from your engineer, we were going to propose to move that to the back over here so that it wasn't. Now, right now, it is a little bit more visible. We have U-Haul trucks stored in the front, but we feel that's a visual detraction and we're trying to locate them here on the side. We're going to add landscaping. You're not going to be able to see the U-Haul truck. So that sign, it will be our only thing that will really advertise to people that this is where they should pull in, which is different than it exists today.
Any other engineering? Let's hit the planning testimony. Sure. Starting.
I'm sorry. Yeah, there is one question. My biggest concern here is that they're parked over the tanks. And when the tanker pulls in, if you have 7 vehicles, 7 items there, you got to move them, right?
You certainly don't need to move all of them.
Really?
Right, because first of all, you have 2 tanks. So if only one of those tanks would be getting fueled at
Yes.
a time. And we're also, as I said, we're not anticipating all the spaces being filled. Only 5 of the vehicles are actually over top of them in the first place, but only realistically 1 vehicle has to get moved to create access to the tank, where they're gonna.
So, okay, so what you're saying is, okay, I thought the fueling truck had to be over the tanks. You're saying the fueling truck is going to sit in the aisle.
Yeah, they're gonna pull up here. They generally come during off-peak times.
Right.
We have a width that vehicles can get around them. They're there for 20,
Okay.
30 minutes. And, again, these are shorter, they're gonna be shorter than they're already shown, and we just need to really create enough room to get it in. But also, you know, their normal anticipation is only one, usually one, probably at most two, would be the 26-foot trucks. The rest will be these little trailers and things.
Yep.
Really won't even interfere.
Okay.
I'm sorry.
It's the same, the operator of the U-Haul is the same as the operator of the gas station. They're gonna be able to coordinate these, you know, and move them, you know, this is what they've come up with as a plan that works for both of those uses.
And they get advance notice whenever
Yes,
there's
they're
any.
they're
type of-
scheduling these things, yes.
Well, one question that had been asked previously that we reserved for you was the striping of the area above the tanks.
Yes, so what we're proposing to delineate the areas, we don't want to provide long striping here because it creates issues with notification to the fuel companies of what they're supposed to be doing, you know, for safety and things like that. We don't want it to be a confusing situation. What we're proposing is that at the front of every one of those stalls, it was suggested that we could have up to a 3-square-foot sign delineating it as U-Haul storage space. So we'll just put little signs like that, which would be compliant in front of each of those. And, you know, if you wanted further delineation, we could even put some sort of a marker behind, you know, at the curb to delineate the edges of the stalls. But realistically, we're also having this, you know, organized and maintained by the applicant. So it's not as if somebody, you know, a pedestrian is going to park here, or I'm sorry, like you know, somebody's going to show up, leave something here out of place, and it's going to stay that way. They're going to maintain this, you know, in the fashion that it is. So they're going to know where those stalls are located.
They're the ones who do the parking in those
Correct.
spots.
Yeah, they have to do the inspection, and they're going to make sure they're placed in the appropriate spots.
Maybe I can ask one more question if I could, Brad Perry. Is there precedent, are there other gas stations where there's the storage of anything on top of the tanks at that gas station? I'm thinking, what if one of these trucks catch fire while it's parked there? For whatever reason, you now have a vehicle on fire on top of a gas tank. And I just wonder, is there any precedent that you store anything on top of them?
There's no restriction I'm aware of related to that. I mean, you know, usually they're kept open for access, but I've seen it like at, you know, gas stations that have fuel, like repair facilities, you know, they'll often park, you know, vehicles over top for service and things like that.
All right.
So there's no prohibition.
All right, thank you.
And I just want to ask something. You guys said up to 7 items. And on the plan on sheet 3 of 4, you have right now 6
correct
over the tank area and 1 in front of the billboard. And did I understand it correctly before when we talked about shortening the length of those spaces, that you would take the one from the billboard and bring it over on top of the tank, so you'd have all 7 on top of the tank area?
So-
Or did I misunderstand that?
It's a little different. So we were moving this northern space where proposal was to put it in the first westernmost stall in the set of 4 parking spaces and take ourselves
Put it this
down.
way, can you take a sheet 3 of 4 and cross that one out and mark it in where you're proposing to put it? And then I'm going to ask Jeff and Tony if they have a problem with that location. Fine.
They don't have a problem with that location.
Okay, so what we're,
The landscaping, proposing as well.
So
yeah. And I want to get this marked as exhibit A1.
So we have a minimal amount of landscaping directly behind the curb. But basically this area here, it's just going to be expanded and increased. And again, I would suggest the condition would be, you know, that we work out the species and thickness with your board professionals.
So that he added something with landscaping on this exhibit A1? So, yeah, whatever you testified to, can you neatly write it up there right now?
He did.
Okay, just what did you write?
It's delineated as LS.
Can't hear.
It's delineated as LS for landscaping, and I created an oval in the area between the curb and the right-of-way easement line, which exists.
And then you stated that the landscaping would be to the satisfaction, review and approved by the board's landscape architectural expert, correct?
if you prefer, or we could do it through Tony's office since he's reviewed the application.
Tony, what's your preference?
We could do it.
Okay.
With nothing further, I can jump into the planning. So the first part of our test here is to prove that the suitability of the site. And there's a variety of reasons for this, some of which I've already touched on. As I stated, the U-Haul and similar rentals are done in a few ways: standalone facilities, at self-storage facilities, or at gas stations. And this is something you can see if you go on U-Haul's website and what the most accessible locations are. This current site has an excess of spaces already to it. And what you've heard is that the applicant has operated this business here for some time in a less organized fashion, and it has not been a problem. So we think that because we have this additional space available to us, it's not used, and that this is a somewhat typical use for these type of facilities and their locations, that would make it appropriate. Additionally, this will be one of the few locations on the northbound side, whereas most of the others again are either much further north on the opposite side of the road, and provides a needed space for that. We also think the use is best suited for a highway location such as this. Other gas stations, that are on more lower classification roads, may be a different story. But the ease of access on the highway, means that people coming here won't need to travel on local roads. We think also that, as you heard, that, Heron Glen is one of their largest clients and most repeat clients. There's nothing better for, suitability than locating them, next to a facility that needs their services. Additionally, we need no physical site improvements to accommodate this use. So it's basically suited as it is in its current fashion. And finally, I think there's an advantage to having these at a site that can fuel them. So, oftentimes somebody needs to drop this thing off. They need to stop at a gas station anyway to get the thing filled up before they bring it back. This is limiting traffic because it's keeping it all at that site.
You're basically saying that the gas station and the U-Haul use have a symbiotic relationship?
Correct. In terms of purposes of zoning that are furthered, I would say that the public welfare is supported due to the convenience of the site, and it is a needed use in the town. You've heard that there are a few other facilities, but it's not as if that it's a large U-Haul, a dedicated U-Haul that has 60, 70 trucks in it. All the local facilities for U-Haul are generally small establishments with a few number of vehicles. And this would be providing them, the most local one to this particular area. And it's, certainly its convenience of use, the people that pick up can fuel themselves here is a benefit. I think we're creating a suitable, desirable visual environment, irrespective of if these vehicles are parked here. The increase of landscaping that we're going to propose on the southern end will also
slow down a little.
Sorry. Will serve to screen not only the U-Hauls, but the site itself from the neighbors. So I think, what you'll see here will be visually improved with this plan through the increased landscaping we're providing. And finally, creating supporting traffic routes that improve free flow and minimize congestion. We can we're obviously increasing the traffic very minimally along the roadway. I think what you heard was, typically 1 to 3 pickups a day during a weekday and perhaps 7 on a weekend. It's insignificant traffic that's being created. And the fact that they can fuel here is reducing traffic. And, having these kind of satellite facilities, if they're put in appropriate locations, is minimizing how much other vehicles are traveling down the road to reach a facility that such as this to serve their needs. In terms of the negative impacts, I don't see any significant impacts here other than the visual. I think the visuals that they have now, where it's, the vehicles are somewhat kept all over the place, that's detracting. But what we're proposing here to locate them all on the side and landscape them, I think that's effectively mitigating the negative impact that these would otherwise have. And in terms of, and in terms of our neighbors, just so we could, again, reiterate that impact, we have a facility that utilizes our service. We have residential housing in the back, 2 individual lots that cannot even see the facility through the screening. And we have a non-conforming residential use to the north that is owned by the same company that owns this property. So there will be no objections from that property. And finally, in terms of impacts to the zone plan, ordinance, or master plan, I didn't find anything in there that was creating a substantial impact on those. The goals of the 2019 examination did not appear to conflict with this use. And I would go as far as to say that the goals of permitting additional non-residential development and providing a safe and efficient roadway network would both be furthered by the application. And then just to touch back to the signage, where there
Go slow.
remain some questions.
So you agree to C2 variance for the
Yes.
signage and the reasons, what are the benefits that of the MLUL that would be advanced?
I think the importance here for the size is the main one that I've heard from some other people is that the need to have this a certain size that this can be seen because of the busyness of the highway. It's
Safety.
safety. Yes, we
Will
don't want
enhance
vehicles
safety.
coming down the roadway and checking their brakes because they missed the entrance. We want them to see it far enough in advance because the entrance is located on the far southern side of the site, whereas the sign is to the north. So we just want to make sure that that's visually seen. I don't really see any detriments to the size because of location. You cannot, when you're coming down the highway, see this substantially in advance. But also, we have a 25-foot height to this sign. It's tall. It's a permitted height. We're trying to put this at the lowest portion of that sign. So out of everything, that's probably the portion that needs to be the largest because it's the last part that you're going to see as you're coming down the roadway. So again, safety really is the key consideration here, making sure that it's large enough to be seen. And that's supported by, again, sizing is similar to the numbers that are on the fuel sales. Those sizes are somewhat standard based upon the speeds of the highway. And we're just matching that because that's what's known to be something that can be visually noticed far enough in advance.
And by adding it to the existing sign, it's not like we're trying to have a proliferation of signage on this side.
Correct. If we had, if we had no signage here, we could consider something different. But we have purposes of zoning about not creating excess waste or trash. It would be a shame to take down this otherwise perfectly functional sign for the sake of trying to reduce the bottom of the sign and bring it up when we're already permitted at 25 feet. This is what we're adding here is not going to be impactful. It's the the lowest thing you're going to see. And again, based on the location and the geometry and the steepness of the road, leading up, I think it's necessary for visibility.
I don't have any questions, Mr. Ingram, because he covered it all as far as I can see.
Questions from the board? Let's close for deliberation.
Before you do that, Jeff and Tony, number 9 on your, I'm just trying to go back to this billboard. Number 8 is the billboard.
Right.
Number 9 says, please provide a copy of the NJDOT permit for the billboard.
Did they ever do that? No.
This is
Again,
the
we don't
The
have.
billboard,
control
I'm talking
over a
about.
Billboard or anything. That
Yeah,
would be the owner of the
I
property.
understand, but you could do an Oprah request down to the DOT to get a permit for the billboard without contacting the owner.
We can do the Oprah request. If it doesn't exist, we'll just notify you. If it does, we'll provide it. I can tell you that I can see this sign in 1963 aerial photographs. I don't know if they're going to provide us a copy, but it's been there for a long time.
Okay.
Okay, Jeff, in 1963, were billboards permitted?
And
You
it
look at
was-
any
it was
photographs
constructed,
prior?
I would say between 55 and 63, because those are the two photographs I can see. I don't see it in 1955.
First ordinance was 57. You saw it in a 55 photograph?
No, it was constructed between the two.
That's why, again, you already have my suggestion for the
Yep.
condition.
Okay.
I understand the suggestion for the condition, but if the township really wants to pursue this, they can issue a notice of violation to see whether that 7-year gap between 55 and 63 is when it was constructed. And if the township and its police enforcement powers want to raise that issue, they can do so. But to condition the application, this
Can
application
I ask you
on it.
something? Here's my question. As a practical matter, you also represent boards, right?
Yeah, but I'm here
Right.
for an applicant.
I understand you're here for an applicant, but if you were representing a board and your zoning officer told you that the owner's been ignoring him, and you now have an application on a piece of property where one of the variances you want is for the size of a sign, and there's already a big billboard, and it would be very easy to impose a condition, which it's not like, it's not related at all. It's, just- you're in here for relief for an additional principal structure and principal use, and the billboard's a principal structure and principal use. So it's not even like they're here for a second principal use, they're really here for a third principal use, because the billboard is. They're proposing to have a larger sign, and the billboard's a large sign. So you actually have a rational nexus between the two of them. So you think that this condition is unreasonable, or you're just preferring that the board not impose it?
I'm not saying that it's unreasonable, but what I'm saying is that each municipality has the ability to determine to what extent it wishes to exercise its police powers in zoning ordinance issues.
Okay, put it this way.
And let me just finish. If you asked me a question, so I
Yep,
want to
yep,
give you
yep,
the
fair
answer.
enough.
And it doesn't necessarily make sense sometimes for a municipality to go after a property owner for a sign that's existed since 1963, when there's a question.
Whoa.
Let-
Where'd you
let-
get the
again,
1963 from?
That's what he testified to.
But 63 where it wasn't permitted at the time.
Right, but
Okay.
again, let me just finish if I could. If it is an ability of a township to decide, you know what, do I really want to expend the time and effort to go after a property owner when a sign has been in existence since 1963? I'm not sure whether it's been there since 1957 when the ordinance has changed, but do I really want to expend the resources and the power to do that? That's an ability for a township to decide whether they really want to go after a property owner under that type of circumstances. And if they did, they can by issuing a notice of violation and a summons to the property owner, as opposed to these nice people who are just trying to run their business and that don't have any control over the billboard. So I'm not saying that the condition is unreasonable, but what I'm suggesting is that it may not need to be issued, and that the township can issue a notice of violation if they really wanted to go after a property owner for something that's been there since
So
1963.
let me ask you this. So why didn't you guys Oprah the DOT? Because if you Oprah'd them and found that they had a DOT permit prior to 1957, then the issue would have been settled. Why didn't you, why did you leave the issue open till tonight?
Because quite honestly, we had come to a understanding that we were pursuing this application without pursuing the billboard.
You came to an
And-
understanding with who? With Tony and Jeff, or with yourselves?
No, with you guys. Again, I wasn't part of this, but this is how the application was going to proceed, that we were dealing with the billboard on this side. But I didn't get a request for the DOT permit until we got the report on May 27th.
Could have made your bill request on the 27th, even if it wasn't back by now, you could have.
Oh, you will have no
made your
response.
request.
I'll get okay.
Again, we don't mind asking for the permit as a condition. We don't mind doing that. That's,
That makes no sense. Without the.
John, I'm not hearing you.
Yeah,
even if we found
listen, it makes no sense to make a condition having them Oprah to see if there's a permit or not at this point. Okay, either you guys decide, do you care or not care? I could ask Mr. Grunberg another question that how much do you think it costs to file a Chancery Division action and prosecute it to get rid of a non-conforming use? Because I'm not going to testify, but I know from this other case. How much would it cost the township to go that route?
I'm not talking about a chancery division. I'm talking if the township wanted to do a notice of violation summons.
In
they
municipal
can.
court?
Yeah.
Okay, and a fine would be issued. Can the municipal court order the sign to be removed? No.
No. they
Correct?
can- Correct, but they
Correct.
can continue to issue summonses for the
And
fines.
listen, as a practical matter, because you know the answer, what's the municipal court judge going to do?
Have you come back here for a use variance application?
And what happens
Or
if the applicant doesn't?
he keep doing fines.
Mad cycle for up to 80 summonses over 2 years, right? That could happen.
It might.
Yeah. Anyway, you guys have to decide if you want to impose the condition I suggested about the billboard, or if you want to take Mr. Gruenberg's suggestion and say, it's not our problem, we're going to ignore it, let the township committee deal with it.
It's not that it's not your problem and ignore it.
Well,
It's that
okay.
it's not that
Wait,
they can,
silent.
they,
Hold
they-
on.
they don't have to exercise jurisdiction. They can leave that with the township to decide
Yeah, but
whether
wouldn't that be
they want to
ignore,
exercise.
that would be
their-
ignoring it, right? That You're asking them to ignore it, which if, I told them in the beginning, if you want to ignore it, you can, but how can you say that they wouldn't be ignoring it if they didn't say something about it? Tony,
They're
is there-
saying that we haven't requested relief for it, and if the township, and the status of that sign is in question. And it's.
That's, with all due respect, that's worse for the township than if they just ignore it. Because now the township's on notice that the board says there might be a problem. Then if they don't do anything, you're helping the billboard company or whoever owns it, making a estoppel argument. So in my opinion, you should either ignore it or impose the condition that I suggest, and it's totally up to you.
Does the township maintain records this far back in general on properties? Because I find that, it gets to be somewhat unfair at a point where, people are asked to prove something that's been there for
Wayne,
60 plus years.
With this one, there's an NJDOT permit that had to be issued.
We know that was still done in the 1950s or 60s.
I believe that actually the first highway signage act was 1965.
And we know the sign was there in 1963.
Well, but if you Oprah, you'd find out. But again, this is a circular
And
argument.
it becomes difficult for people to, like, who, when they put up a sign, bothers to take a photograph so they have constant proof for eternity that something was built.
You know what?
prior
Let's
to
get
it.
it on the record. What kind of discussion did you have with these guys about this billboard sign? Let's just put it out there then. If you're saying, oh,
Not hearing you.
sorry, I said, let's get something on the record from Tony on the exact discussion you guys had with them, because what the record right now is reflecting that they were totally surprised on May 27th
That's
when
not
they
what
got
I
their
said.
request.
That's not what I said. That really isn't, no, that's not, I mean, no one said that. But let me, we knew that the billboard was assigned was an issue since 2021 when the application was first filed, before my
And
involvement.
you said you reached an agreement.
No, the understanding was that we were not going to include relief for this sign, the billboard in this application.
Okay.
And that's all I said.
Oh, I read more into what you were saying. I
No,
thought there
not
was an
that they were
understanding.
disregarding the sign, that they weren't going to raise it. I never indicated that. The only thing about the request for a DOT permit to look for that request for us to do that research didn't come up, as far as I know, since May 27th, when I got the technical review. But
So, again, I'm trying to remember what was discussed, but a lot of stuff was discussed about the sign with Tony Kester. Wasn't really discussed with Steve Kronberg.
Because Tony Kester was representing the applicant until he abruptly retired.
And Tony Kester reached out to Ewing Oil, I believe. And I spoke with a representative, and he gave me the runaround for a couple months, and we never got any results.
No results from Ewing Oil, that is.
That's correct.
Is there any other way that you can go after Ewing Oil? I mean, we're
again-
dealing with a tenant here who really has no direct responsibility for that sign? Is there any other way that you can approach this? I realize you've given 80 violations.
So
To somebody else, not on this.
no, we didn't issue a notice violation to them.
No,
because-
I know that.
Yeah,
I-
somebody
to
else.
Ewing Oil.
Yeah.
Right.
No,
Is there
not,
anything else that you can do?
So the court has changed a bit in the past couple of years. We usually,
The municipal court.
the municipal court, we usually issue summonses, it goes before the judge. If the applicant doesn't appear, they issue a bench warrant, police picks them up, and the issue is resolved. So now the court system or the judge cannot issue that bench warrant anymore. So we could write tickets as much as we want, and there's nothing we could do.
In this case, we never issued.
Yeah, microphone. No, they understand you never issued.
no, I don't think they did, because I thought the chair had thought that the 80 summonses were issued to Ewing Oil
No,
on
no,
this
no, no,
matter.
no.
Is that-
Ewing Oil.
No, it wasn't.
That's a different
No,
product.
that's a different case altogether.
But the chair, I believe, was under the impression that 80 summonses were issued to Ewing Oil.
Yeah, that's what I thought.
Oh,
And it's,
no,
and
that's
it's,
wrong.
and
No,
that
no,
wasn't
no.
the case. No summons or
Okay.
violations been issued to Ewing Oil. Folks, I think everybody, I'm hoping everybody recognizes that this is a good use for this site, and it serves an important function for the community. I'll leave it up to you to what extent you want to condition an approval dealing with the billboard. We've separated it out. We're not asking for an approval. And we think that if the township wants to enforce what's something that's been there since 1963, they can choose to do that by way of notice of violation as opposed to conditioning us. But if you're going to condition it, as Mr. Drill suggested, that is certainly within your purview. We ask you not to do it because I think the township has other avenues, but we'll leave it up to you. This
I'll
is a
give you
good use for
one
the
other
township.
Precedent, again, nothing serves as precedent in a land use and zoning case. But whoever was on the board at the time that the solar application on, Millennium on Reeville Road? What- Everett's Hill, Everett's Road, and there was a billboard on the property. And the board granted the application and put a condition that the thing had to be removed or they had to apply. Lo and behold, it was removed. That's how you get someone's attention.
Okay, so,
I would just say the difference there was you were talking about an owner who was going to receive millions of dollars as compared to this having no effect on what, the owner is going to receive in terms of value, won or lost.
Were you the engineer on that one?
I was on the board at that time.
him and Kevin.
If the
You
owner was
you
gonna
like
get
that, you like that condition
If
at
the
the
owner
time,
was going to
didn't
get
you?
millions of dollars if this application were granted, I guarantee you'd tear down that building.
You were the chairman of the board at that time.
Tony, is there any other way that you and Jeff can hold Ewing Oil responsible for this?
So what is the penalty to this applicant if we put the condition in? Will they not be able to move forward until this condition is met?
How about this? We put the condition in. If the condition is not, first of all, no one, they currently have a U-Haul operating. out of the
Well, that's what I'm saying. They're currently doing something they shouldn't be. The
Correct.
billboard is something that
Just
maybe
hold-
not
just hold-
be.
just hold on. So my concept is you put the condition like I suggested. If at the end of 90 days, the thing is still there and they haven't applied, then they can come back and seek to have the condition eliminated, but at least have the condition in there so that they're going to send it to the owner and maybe they'll get something done. If you don't have the condition,
Okay.
trust me, nothing's going to get done.
Okay, so then they have the option to come back and ask for it to be removed
Because quite
so they
frank-
can move forward.
Correct, because quite frankly, Tony, they're not going to issue them a violation now for the U-Haul, since you guys are granting it tonight, but I'm not going to have the resolution done for who knows when.
All right, then that sounds better.
It's fine.
Okay. Close.
Okay, can we close discussion? Who'd like to start? Cynthia?
Again, there isn't, the only reason the chairman's not opening to the public is because the chairman ascertained before that there is no public here.
There is none.
And we should just check who is on Zoom, Amy. Is it just our board stenographer and Steve?
There are two people besides Jackie and Steve that are on Zoom.
Oh, let's see if they're members of the public.
Are there any questions for this witness from the public?
They're not raising their hands or unmuting. so-
Maybe it's the owner of the property or the owner of the billboard.
Could be.
Oh, Go ahead.
Mike.
Could you just explain the U-Haul, that's going to make a third principal use?
Yes. Well, we're going to have the resolution terms. It's going to be an additional principal use. Okay? Because we don't know if that billboard doesn't belong there and it gets removed, it would be a second principal use. If the billboard is grandfathered, it will be a third principal use. The way the board has interpreted the ordinance, which is now binding on everyone in the township, is you can't have more than one principal use. This is an additional principal use.
So the mini mart and the fuel station,
It's considered one use because the mini mart was deemed by the planning board as an accessory use, not a principal use. Even though if today they came in, both the board and the planning board would no longer say that. The planning board said that, and they're entitled. They have a resolution saying that. No one can take that away from them. It can change for future applicants, but they're grandfathered.
and anywhere in this, what we do tonight, is there going to be a condition about the hours of operation changing?
The condition is going to say, in the findings, I'm going to reference the fact that there was this condition, but the actual condition is going to say that all terms and conditions of all prior resolutions shall remain in full force and effect. Why am I going to term it that way? In case there's some other resolution floating out there that modified it, because now he's going to Oprah that. Sure. And if the township comes back and says, we don't have those records, then they're gonna go to the landlord. Lo and behold, they're gonna find it, I bet. This is all motivation.
Okay,
To answer your question.
Thank you.
Okay, I would be in favor of this application. I don't know if it's needed, but I hope Steve will speak to that. I think it's in a good location. My concerns were around the number of vehicle or items and parking over the gas tanks. And I think there was testimony that satisfied my concern there. And I think the location, and if the need is necessary for the township, I would be in agreement.
I'll go second. I'm very familiar with this site. I've rented there on a number of occasions going back to the time that the applicant first started leasing. On occasion, I have been forced to go as far as Route 22 up to Branchburg because very often all of the U-Haul trucks within the township during the summer on Saturdays and Sundays are utilized. I have gone to Life Storage. They had no vehicles available. The applicant may not have had vehicles available at that time. I've been forced to go up to Branchburg, where there is a large facility up there. This site is really ideal for this facility because of the fact that it's a very large property which you drive around. If you noticed in the plan that Wayne presented, tractor trailers go around the back of this property and they fuel on the back side corner of this property. Vehicles, cars fuel in the front. In the past, the only concern I have is that the U-Haul vehicles were placed out in front of the gas pumps. And I think part of the reason was there was no sign for the U-Haul. And that way, as Steve Farcio pointed out, you could actually see that there were U-Haul trucks there. I think this is something that's needed in the township, especially now that Life Storage apparently has decided to give up these vehicles being rented at their location. That means Stowaway Storage and Liberty Fuel are the two places in the township where you can rent a vehicle. They have pickup trucks, they have box trucks, they have trailers. I've never seen this site overloaded with vehicles. It's always been a limited number, 5, 6, 7. I really endorse this application simply because I think the service is needed within town. And I think the changes that Wayne is proposing are excellent. With regard to the billboard, I think a condition ought to be imposed, but I would welcome the applicant to come back in 90 days to ask that that condition be removed if in fact we can't get Ewing Oil to come to the table and resolve the issues that we have with them. So I've been very long-winded, but I do endorse this application.
I might as well go next.
Good, very good deliberation.
So Jackie, Steve Farcio, I will echo what Roger just said because I think he hit every issue that I can see. And he also brought up a very good point and reminded me that if not for this facility, I remember, I think I used this once or twice. I think I had to go to either like Trenton or I had to go all the way to Branchburg or somewhere else. Even though some of these places say they have vehicles, they're never there. So I don't know why some of these places even advertise it. It's a perfect location. There's no doubt in my mind there's a perfect location. And this, the way it was presented was excellent. And I think it demonstrates exactly why we need this. And I can tell you as a resident, we definitely need it. There's no question in my mind. And all of this is only going to help the residents and even people outside of Raritan Township, because it's actually going to be visible. You can deal with people who actually, you know, really helpful people to get what you need. And there's not going to be any confusion. I mean, the confusion was the biggest issue that I had. So I was glad to see this application when I saw it come in. And I think this is a no-brainer. I agree with Roger, and I like his recommendation about the billboard. You have to, I understand that that's an issue and that really is not fair. But I think, you know, John made a good point about that as well. So I would agree with the condition on the billboard of 90 days. Hopefully Ewing Oil comes to the table, but I'm all in favor of this application.
I don't think
I want to add something to it. Question is not about whether this business is required, and you heard all the good things, and I support all that, right? It is required, it's needed, and it's going to provide a lot of service. My concern, and I think, John, you have put in, I just want to overemphasize, is compliance. There is this, right? Compliance about hours of operations. You guys said the U-Haul is going to be used 9 to 9. So I want to just overly emphasize that needs to be taken seriously, which has not been taken.
Good point, by the way. Right. So there will be a separate condition on the hours of operation of the U-Haul, which will track what they testified to. The other conditions of the prior resolutions will also apply. That picks up the hours of operation of the gas station.
Correct. So you need to be serious about this, that you are going to comply, which you haven't so far.
I don't have a lot more to add. That
I think that the site very adequately can support the additional trucks. It's basically a fueling point for trucks, and we'll be storing U-Haul vehicles there. And I want to just emphasize, I think that there needs to be a condition regarding the billboard question that goes back and forth, because quite honestly, any variance runs with the land and runs with the property. This tenant may come and go, and that billboard could still be there, and it's likely some supporting paperwork, but to ask for that now, when you're asking for the variance, I think is well within the bounds of the township.
Brad Perry, I don't have anything additional to add to what my colleagues have already stated. I would be in favor for the application with the restrictions, related to the billboard and everything that's already been said.
Randy Block, I agree with all my colleagues. I think they said everything that I really wanted to say, but one thing, years ago, I was moving from my current place to my current office. And I had to rent a U-Haul, and I had to go almost 20 miles to find one. And if this one was local, it would have been a lot better for me. So I agree with this application 100%.
Make a motion.
I don't.
Oh, go.
Hi. I'm going to vote in favor of this application, but I'm troubled by it. I'm troubled by the fact that the applicant is unaware of the conditions that were placed on this property, because it's with the property, not the owner of the property or the operator. The conditions follow the property. So that means whether you are aware of it or not, there may be restrictions on your use of this property and conditions. That's one thing. Second is, I'm concerned about what I see as a Me Too kind of attitude in the area, whether it's a billboard or a U-Haul application or whatever. We never seem to get one of anything. We seem to get
Like
one.
the
and then
flex
multiple.
space,
Huh?
the flex space things.
Well, the point is,
Right.
to me, it's like a Me Too type of thing. I don't know why. But in any event, I'll vote for it. But I think council, you'd be doing a great service for your client if you sat down with them and explained to them what this is all about. The original resolution.
Already talked
Approving
about it.
the property.
Okay, make a motion.
Anyone else? Bill?
My only comment is in trailers, when you're renting trailers as an owner, I've seen a lot of people not know how to hook up a trailer. They don't have their proper hitch. There's all kinds of safety issues. So I'd make sure when you rent trailers that people, I don't know if you have somebody go out and inspect them before that while they're on your property, but there's
Yeah.
a lot of boneheads out there. Anyway, but you don't want that kind of liability.
Okay. Someone care to make a motion?
I'll make a motion.
I second it, Randy Block.
The motion is to grant all the relief, subject to all the conditions we discussed, in addition to the board's regular conditions, correct?
Yes.
Zoning Board Chair, Mr. Roger Aaron's.
Yes.
Mr. Kevin Cool,
Yes.
Ms. Cynthia Schaefer,
Yes.
Mr. Randy Block,
Yes.
Mr. Steve Farcio,
Yes.
Mr. Jim Ferraro,
Yes.
Mr. Bradford Perry.
Yes.
Thank you all very much. And
Okay.
thank you for having us come back and be able to finish tonight. That's really greatly appreciated.
Weren't you glad?
I am very glad.
Jessica's not.
No.
Have a good night all.